Item number 14.
Item number
14, man.
14.
Last Wednesday, we have received the affidavit in opposition filed by the state government. Now, there are certain averments which we need to reply to. I'm seeking at least a week's time.
Okay. How much time?
A week's time.
Okay, Mr. P. Bharadwaj, Learned Counsel for the petitioners, has submitted that he has received the copy of the affidavit in opposition of the state respondents recently.
I think the affidavit is filed by the railway. I think.
Okay, railway
Railway.
affidavit
Railway.
in opposition of the respondent railway authorities, and has prayed for a week's time to file an affidavit in reply to the said affidavit in opposition. First of Mr. Lekhak, Mr. P. Bharadwaj, Learned Counsel for the petitioners, and Mr. H. Sharma, Learned Additional Senior Government Advocate, Assam, for the state response, and anybody, revenue. Okay, are present. This is the case after a week. Only 2 weeks by the office.
May it please your lordship.
Yes,
I pray for listing of a matter for motion on Thursday or Friday.
Friday it will come automatically.
Sometimes it gets delayed, your lordship.
Automatically it will come. If
Friday.
it does not come, then you try.
May please, your lordship. Lordship, with the consent from other side, I beg to mention item number 8, lordship. Lordship, I am appearing for respondent number 3 and 4.
8. Yes.
Lordship, due to for some personal difficulty of the learned senior counsel, lordship, matter will be adjourned
Okay.
for today. Lordship,
Who is for the petitioner?
I'm for the petition.
Miss
D. Devi.
D. Devi, Learned Counsel for the petition is present. Mr.
BP Sharma.
B.B. Sharma,
Lordship.
Learned Counsel appearing for the respondent number 3 and 4, has submitted that Mr. J. Roy, Learned Senior Counsel, who is leading him in this case, has some personal difficulty today. So he has after what time?
Lordship, maybe about a week vacation, lordship.
He has paid for listing of the case after 3 weeks. So as the prayer made on behalf of the respondent number 3 and 4 is not opposed by the Learned Counsel for the petition and other sides. The praise allowed is the case after 3 weeks and 2 weeks by the office. Mr. M. Borman, MS M. Borman, Learned Government, Assam, Likhidibo, Namtu. Yes.
Obliged.
May it please your lordship. Your lordship, I beg to mention item number 10, your lordship.
Item number
10, your lordship, with
10.
the consent of the other side, your lordship.
You are for the petitioner,
Yes, your lordship.
Miss
B. Soren, my name might not reflect in the
B. Shoren, Learned Counsel appearing for the petitioner, has made a prayer for adjournment, with the consent of the Learned Counsel for the other sides. As paid for, release the case after
4 weeks, your lordship.
4 weeks.
Obliged, your lordship. May I please your lordship? Lordship, I beg to mention for listing of a WPC for admission, lordship, on Friday, lordship.
What is the subject matter?
Lordship, it's a land grabbing matter.
Next week.
Date
Monday.
may be given, lordship.
What must will give the date?
May it be please your lordship. Lordship, I beg to mention for listing one WPC matter in admission.
Subject matter,
Lordship, it's a railway matter, permanent closure of unmanned level crossing, my lord. My lord, in this matter, we have already filed affidavit in reply, and as per last date, that was not tagged.
bench 4.
Obliged, your lordship.
For 12, item 12.
May I please your lordship. Lordship, this matter become infectious, so I may allow.
Okay, Mr. S. Ayakan, Learned Counsel for the petitioner, has submitted that you have really got the relief or what?
Relief.
The petition has already got the relief, sought in this writ petition. And as such, the petition doesn't want to pursue the writ petition. MS M. Borman,
State response.
Junior Government Pocket Assam for response number 1, 3, and 4. And Mr.
Chauhan on behalf of Ms. Arish Chaudhary.
R. Chauhan, Council representing Ms. R. S. Chaudhary, Planning Council. Assam State Legal Services Authority for response number 2 are present. Full stop. In view of the above submission made by Mr. Akan and Council for the petitioner, the petition stands closed.
Established. Daily list for motion, item number 1.
My lord, last occasion, the lordship has directed me to, with the notification to affidavit I have brought, my lord. Annexure,
What is the case?
my lord, here our village is Tambutola.
Petitioners are the resident of village Rambutol, Kungur Gaon Panchayat, under Sonai LSC. After delimitation, Gaon Panchayat. Come to your synopsis.
Yes, my lord. When
Earlier, you were resident of Tambutala,
yes,
Tambutila,
yes, Tambutola.
Kungur Gaon Panchayat,
Yes, man.
under Sonai LSC.
Yes,
After delimitation, the state Gaon Panchayat was attached with Borkola LSC, meaning thereby, during LSC delimitation,
yes. That was acted upon
Ah.
total list
or what?
prepared.
One minute. Okay, let us see the MP LSC delimitation, parliamentary. Okay, in your additional affidavit.
My lord, annexure H102, this is the proposal.
Okay, this is not proposal, this is final.
Yes, this
11th
is
August is final.
subject to Election Commission of India.
This
Notification.
is LSC delimitation.
Yes.
Now let us see
Then
your
final is my lord annexure I-106. This is the Assam government of the cabinet decision and as per.
no. Come to 102.
This is a proposal, my lord. That,
Oh, there is a finality already, 11th August.
yes. That,
11th August, where is that 11th August?
that was not with me, but 15
Not with
October,
you.
my lord. This is the 15 October, my
No.
lord. Government of Assam, my lord.
Election Commission of India. What is your case?
My case is that
Election Commissioner 11th August.
my case is that Ghungur Gaon Panchayat before delimitation is proposal is given.
No, there are two delimitation. Don't confuse it.
Yes.
One is LSC delimitation.
Yes.
So prior to LSC delimitation, your houses are in Sonai.
My Gaon Panchayat is in Son. Proposal is given.
You are in Sonai or Borkhola?
Borkhola.
No. During, before LSC delimitation,
Yes.
your houses
My
are in Sonai or Borkhola?
it is Sonai because
Earlier,
yes.
prior to LSC
Yes,
delimitation.
my Gaon Panchayat Ghungur West
Wait for Ghungur.
Sonai.
And after LSC delimitation,
My lord.
your houses is in Borkhola LSC.
Yes, one of them.
And from where you cast your vote
Yes.
during MP and MLA election? Borkhola.
What happened, my lord?
No, I am yes or that can be answered yes or no.
We cannot cast vote because fraction of the villagers somehow attached to this Sonai.
That is done. If that attached, no, it is final.
No, my lord. Because there is a notification that if any discrepancy, you can.
No, there is this. You have annexed it 20 June 2023.
Yes.
There is 11th August 2023.
Yes. And after that, my lord.
In 11th August, where is your Borkhola?
Yes.
Mr. Dubey, these are factual things to understand first.
Page 122, kindly see, my lord. This is the
Please check also yourself. It is not the burden of the court only.
106, my lord. That is the notification, my lord, by Governor of Assam. Governor, my lord, notification 15 October.
Otherwise, your village Gungur Gaon Panchayat is under which panchayat?
Oh, Borkhol.
Ancholik.
Ancholik is a Tapang.
Tapang.
Yes. So this annexure I reflects there. 106 page. 15 October 2024.
1 minute.
Relevant page 122.
This is Kachar.
Kachar district.
Now, which Ancholik Panchayat?
My lord, page 122, my lord, kindly see page
122.
nine. It is Tapang.
Tapang.
Yes.
Tapang. This
And
is 1 minute.
Borkhai Ghungur, it is.
Or 1 minute. We go from up, top to down. District. It is district.
District Kachar. my lord.
Kachar.
Yes.
And that Tapang is under which LSC?
My lord, Tapang is under, my lord, 117 Borkhola LSC, my lord.
Borkhola NSC.
Yes.
You said 120, right?
122, my lord.
122.
Yes. Column number 9.
Tapang.
Yes. And Borkhai Ghungur is the
1
Gaon.
minute. Borkhola.
And 134, kindly see, my lord. This is a Google map shows that Tamputil and Borkhai Grand, that is now same village, my lord. After delimitation, so Google Maps also shows that is why I brought it. So now Borkhai Grand and Tamputil is the same, and it is under Tapang, Ancholik Panchayat, and Borkhai Ghungur Gaon Panchayat. And it is under Borkhola LSC.
Borakhai Kungur. Mr. Dubey, do you have the big one? Election Commission of India. Huh? big one. This Tapang is under Borkola.
Yes. And our village, my lord, that is now Tambutila become Borkhai Grand, my lord, is Google Maps also
Hmm?
shows. Now it's
Borkhai Grant.
yes, Borkhai means,
Huh?
page 134, my lord. Tambutila alias Borkhai, now after delimitation. It
That
became-
is your village,
Yes, our village and
but Gaon Panchayat is
Ghungur West. It's renamed
Ghungur
as,
West.
renamed as Borkhai Ghungur.
And your village is
Now it is Tambutila alias Borkhai. But it's page 134, it is the, now it's a Google Map shows that. Tambutila no longer existed. This is after.
Borkhai Ground.
Yes, now it is.
Borkhai Ground.
Yes, ma'am.
Borkhai Ground.
Yes. Now,
Borkhai Ground.
so
Borkhai Ground. Borkhai. Borakhai Ground.
Boracay. Yes,
Borakhai Ground.
Boracay. Acted upon that note. Page 19. Preliminary voter list issued.
As per the Election Commission of India, entire Tapang development block, which is co-terminus with Anchalik Panchayat, is within Borkala LSC. Now, if Tapang, within Tapang development block, if this village has already been included, where is your earlier, when, before that, what was your Anchalik Panchayat?
My answer, our answer is Ghungur West, my lord.
Anchalik Panchayat.
Anchalik Panchayat, okay.
I'm asking Anchalik Panchayat.
Ghungur was under Borzelenga or something, Borzelenga. Algapur, oh, Algapur.
Your Election Commission of India. My God. Come to 67. This is Election Commission of India.
Yes.
Now, at the time of LSC delimitation, you are under Borkola, LSC.
After delimitation, yes.
So
voter list is, identity card also issued to that effect.
for Borkola.
Yes,
Now tell me within Borkola LSC,
yes.
whether Anchalik Panchayat, what is the Anchalik Panchayat
Now it is.
of your village, earlier or present?
Anchalik Ghungur, my lord. Ghungur is.
Anchalik Panchayat is not
Oh,
Gungur.
Tapang,
Yes.
Tapang, my lord.
Earlier Tapang, present Tapang.
Earlier, my lord, earlier Anchalik Panchayat is different, my lord. But now Panchayat is Ghungur, it is now,
I am not on Gungur first.
yes, yes.
Please.
AP.
You are district Kachar. Okay.
Yes,
Then thereafter it is after before Sonai, now it after LSC delimitation, it is Borkola.
yes,
Within Borkola, there will be that is LSC,
LSC,
right?
yes,
And all the rural areas
yes.
will be
Under
Anchalik Panchayat.
Anchalik Tapang.
Right.
Yes,
So Borkola LSC is to be divided into a number of Anchalik Panchayats,
yes,
right?
yes.
And one of them is Tapang. So this development block Tapang is earlier existing,
Earlier existing one.
so also presently existing.
Yes,
So you are in Tapang.
Tapang.
and Tapang has brought into Borkhola.
Borkhola.
Now, Khungur,
Under Tapang.
now one GP, let us assume one GP, earlier GP was your
Ghungur.
Khungur. Now,
Now also Ghungur.
Ghungur.
Ghungur dot Borkhai gram.
Borkhai, it may be renamed,
Yes.
right? Now what happened to you?
Now what happened, my lord? Our voter list is prepared, but suddenly, my lord, some of the fraction of the voters, by mistake or somehow, it is attached with another Sonai LSC, my lord. That is, we are not
End
concerned.
of the matter.
So that is the problem.
That is by LSC delimitation.
Nothing.
They are out. You are in. Nothing.
My lord, then page 7.
That is by LSC delimitation.
Well,
That part of the village were taken to Sonai.
No, part of the village not taken, my lord. There is one notification. Of
Gaon Panchayat,
Gaon Panchayat is in
whatever.
but villagers, my lord, voters.
They have been bifurcated by the LSC
So there is
delimitation.
no process about that. No notice. How?
Election Commission of India.
No, my lord. That is why, my lord.
That is why you don't.
Page 79, kindly see. Apprehending that there should be some mistakes. So
No
there is-
mistake.
There is
I
some
don't find
provision.
any
My lord,
mistake.
notice is given, page 79, annexure.
A notice is given.
Yes. My lord, some centers was created that if you have some discrepancy, you can make an objection to that or any. My lord.
Then any representation, then you dispose
Yes,
of.
yes. My lord, then we file the representation that yes, there is some
Repeat.
discrepancy kindly.
Because it appears that Ghungur Gaon Panchayat original was bifurcated at the time of LSC delimitation. One part has gone to Sonai, the other is in Borkhola, and entire this process, Panchayat delimitation process, that 11th August 2023 has been taken as a base and proceeded accordingly. So they remained as per the LSC delimitation.
But our case is different.
I have understood your
Yes,
case.
I understood, my lord. Whole Gaon Panchayat is attached with this Borkhola LSC. How can they say where is the notification, my lord, the village is bifurcated? That is, my lord, not there.
Mr. Kumar and Mr. Be ready with this particular.
It is some clerical mistake or something. I don't know, my lord. That is why.
Tapang development.
Yes. Where is the
It's a
notification
whole-
bifurcated?
Mr. Dubey, you should be ready with that. What is the harm? Hardly half a kg. You should run this. Be ready with the facts.
And my lord, initially, why then this has issued our.
Now you are in Borkhola LSC,
Yes.
Tapang Ancholik Panchayat,
Yes, my lord.
and Borkhola
Borkhai.
Borakhat Grant
Yes,
GP.
village, yes.
That is your grievance.
Yes. Now,
Of some villagers.
some villagers somehow.
So tell me, what kind of right is right to vote?
My lord, when
I am asking you, I don't know, I'll study.
because my lord, our
A
village
right
is,
to vote is what? In
Yes.
Panchayat election is what? Fundamental right?
that is okay.
Or constitutional right or statutory right?
My lord, one.
No, your right has to be violated,
Yes.
right? Your right to vote is intact.
Yes.
Your right to vote, whether it is fundamental, constitutional, or statutory or legal, your right to vote is intact. That has not been taken away.
No. That is-
Right?
Right.
Now, what kind of right is violated? Tell me.
My lord, once as a SOP for notified, village is notified under Borkhola LSC, consensus village. How can a pick up some of the villagers who attach with, what is the procedure? Because they have the power, there should be a logic or reason. Because husband-
then that will require detailed hearing logic.
Yes, husband is voter
Okay,
of.
we'll issue notice.
Yes.
That will require detailed hearing.
My lord.
Borkhola.
One.
Borkhola. Okay, let them respond. What is your exact grievance?
Exact grievance is that once our village or our Gaupons is notified under the 117 Borkola LSC, fraction of the villagers, who is including these petitioners, they are attached with another Sonai LSC under Baskandi,
These petitioners are attached with whom?
attached with the Borkola LSC.
Don't, and other part of the village is attached with,
Whole village is attached
our whole village is attached with
with Borkola LSC.
Borkala, let's say.
Yes.
So, what
No,
is,
but when Gaon Panchayat elections, the voter list is prepared, some of the villagers found that their name is attached with another village or another, means under Sonai LSC. So that is their grievance. They raise the objection before, as per
no, what is the grievance of the petitioner?
petitioner.
They want to remain where?
Yes.
No, you don't espouse the cause of others. Don't espouse the cause of others. What is the grievance of these villagers,
villager
petitioners?
Supposed to be the voter of Borfala LSC, but in voter list they found they are voters of Sonai LSC.
These petitioners?
Yes, these petitioners.
These petitioners?
Yes.
Where did you state?
My lord, Annexure D, my
No,
lord.
no, where did you state? Statement. I'll go by the statement.
Yes.
Don't say name of the some of the villagers, the petitioners. We are
Petitioners.
concerned with petitioners,
Yes, yes, including the petitioner.
not including the petitioner, only the petitioners.
There is.
This is not PIL. You are
Petitioner.
not Little Indians.
Yes, my lord. This there came here, my lord. There is the, my lord, here I have written. Hey, my lord, please,
Which paragraph statement?
para 6.
Para 6.
Actually, para 3 is starting from there. Para 3, 4, 5, 6.
Let us read para 3 together.
Yes,
Okay, and then I will understand.
yes, my lord. This petitioner stated,
Loudly.
petitioner states that they are originally voters of village Tambutila under Ghungur GP, Silchor, which one
Silchor? You are in Borkola or Sonai. How Silchor?
GP.
How?
Ghungur GP, my lord.
Why Silchor?
Actually, in voter list, comma, Silchor.
Copy paste.
Yes.
How can I understand?
Silchor is,
Mr. Borua, how can I understand?
my lord.
I read the,
Yes, yes,
I don't visit the villages.
yes.
I read the petition only. Khungur Gaon Panchayat, okay, we omit Silchor,
Yes.
which once fails under Sonai, LSC. However, during delimitation, during delimitation means LSC delimitation.
Yes. Brought
Okay,
under Borkhai Grand, part 4, under Borkhai.
Khungur, rectified under said Khungur Gaon Panchayat has been brought under. So entire Khungur Gaon Panchayat has been brought under Borkhai Grand Part 4. What is this?
It is renamed as Borkhai Ghungur GP and under.
You
Borkhai.
tell all these things. How can I understand?
Yes,
Khungur GP has been renamed
yes.
or what?
Yes, renamed.
This is difficult to understand. All these are confusing.
Borkhai.
Hard,
Borkhai
Mr.
Ghungur.
MJ Borua. I try to understand, but you have projected in a very complicated manner. Only they will understand with their reply. I try to understand. but I
So-
could not understand.
Yes. Borkhai
I
grant,
tried to mitigate your grievances, but I'm unsuccessful
yes.
to understand your exact case.
Exact is this, it become Borkhai, Hungur,
You are also not sure. Heard Mr. M.J. Borua, Land Council for the petitioner. Mr. K. Moore, Additional Advocate General, Assam, and Senior Standing Council, Panchayat and Rural Development Department for the response number 1,
1, 3, 4,
3,
5,
4, 5,
6, 8, and 9.
6, 8, and 9, and Mr. R. Dubey. That Standing Assam State Election Commission for the response number 2 and 7.
2 and 7.
Full stop. The petitioners are aggrieved by inclusion of their names in the electoral rolls what synopsis is also very confusing.
page 80, my lord. That is the voter list, page 80, annexure,
Tell me your grievance. I have not understood.
my lord.
Tell me in the electoral rolls of
Gaon Panchayat election 2020.
no, which government chat?
My lord, this is now Gaon Panchayat of my lord, Baskandi and Gaon Panchayat.
Baskandi, where from Baskandi has come?
Sonabari Ghat. My lord, page 80 is clear, my lord. That is our grievance. Name-
Sonabari, then why you have taken me to 122? Issue notice returnable in 4 weeks. As Mr. So-and-so has appeared, accepted. Issuance of formal notice stands dispensed with extra copies within 2 working days from today.
Note, I will.
I tried for half an hour. You have taken me to an entire Kasar district. This is too difficult to understand.
Actually, such discrepancies, this I will give a note, my lord. This is not so big issue, my lord. Very
No,
small,
your
but I cannot-
somewhere Silsor, Banskandi, Sonai, everywhere, every 10 Gaon Panchayat names are appearing.
Yes.
Your petition,
So I will give a small note next day, my lord.
I have to
Yes, yes, I should.
take some medicine for
Yeah.
headache.
By that time, they should obtain the, my lord.
Better come up with proper instruction.
Item 2,
Obligation.
right. In this case,
What has happened to Rustom?
So A Sudhani will also be going lordship, my lord. He can give my lord. So my lord, then maybe listed next week, my lord. Otherwise,
Shifted 3 number of villages. You belong to which village?
I'm not instructed.
Puthimari.
Case, my lord. So my lord, Mr. A Sudhani will argue, my lord.
This man is still hoping for to stand in election or what?
No, my lord.
Huh?
No, my lord.
Prayer of my friend is something different.
Okay.
He said that council is different, but they will argue next week. He's not been instructed.
But let us see, impugn notification or inclusion. Okay. Setting aside passing impugn notification. Mr. Moore, see the prayer. And the way. Impugn notification dated so and so. Okay, I understand. So for inclusion of villages, namely, number 1, Borola Khaiti, number two Borlakhaiti and number three Borlakhaiti within the territorial jurisdiction of Mongondo LAC. That has been done by
Done.
Election Commission of India long back.
My senior will.
No, I'm trying to understand. I
Yes.
give the time, but
Yes.
since it has come to my notice,
Yes.
let us understand so that they can also respond in the meantime.
Yes.
This was pointed out by your lordship on last occasion.
Case number 15.
As to why I read in the nature shall not be directed to retain the villages. This is, you have to challenge it before the Supreme Court.
Case number 15.
Election Commission of India notification.
Yes.
By that, the villages have been
Already.
taken out.
Yes. Next week.
This is nothing.
Yes.
Mr. S. Islam, Learned Counsel appearing for the petition has paid for listing of the case after a week. Nothing. That process has to be challenged. Mr. K. Kaur, Learned Traditional Advocate General, Assam for the State Respondents, and Mr. R. Dubey, Learned Standing Counsel, Assam State Election Commission. For the other respondents are present. As paid for, list the case after a week and date to fix by the office.
Item 3.
One minute. Just a line, since I have read it for the next date. The petitioner is agreed by sir, you are not a resident of all these Borlakhaiti. You were of somebody somewhere else.
Yes. Puthimari village. Puthimari.
Puthimari. How you were aggrieved? The petitioner is a resident of village Puthimari. First up, the petitioner is aggrieved by inclusion of villages, namely number 1 Borlakhaiti, paragraph 11 of the prayer, number 2 Borlakhaiti, and number 3 Borlakhaiti within the territorial jurisdiction of Mongoldoi LAC.
Bolgaon LAC. From Mongoldo LAC to.
From Mongoldoi LAC. So inclusion of villages, so from the territorial jurisdiction of Mongoldoi LAC to Dolgaon LAC. Then I'll understand. No need to read the prayer again.
Item 3.
And tell the council, unless he can make out a case, I'll dismiss. Yes, sir.
Lordship, earlier our villages, this is Bormatia Part 2 and Rambu
Firstly, who
village.
are you? How many?
Society.
That also they don't spell out.
President. Who is this development committee? Registered?
Not registered.
Not registered.
Not
Gone. 2 and 3. Tell me the case.
Now
Three. And another committee.
another committee.
Registered?
Not registered.
Not registered. Then tell the case of respondent number 2. Petition number 2.
Lordship.
Bormotia. Manoj Rava. What is his case?
The case is that, Lordship, earlier this
Bormatia.
Bormatia Part 2 and Rambuk villages.
We'll be only concerned with Bormotia, this Manoj Rava.
He also files in a representative.
Tell his case.
Bormatia Part 2 village was earlier under
He is a
Lelagaon,
resident of Bormotia.
Lordship.
Okay.
was under Lelagaon Panchayat, and after draft delimitation, Lordship, the Bormatia Part 2 were shifted to Majakali Gaon Panchayat. And Lordship, if your Lordship comes to the addendum,
Addendum. Impugn notifications relates to inclusion of Bormotia, Part 2 village and Rambuk under Majakali Gram Panchayat, which were earlier under Lela or Lala? Lela. There is also Lala.
LELA.
That is your case.
Lordship, now if your lordship comes to page 61, annexure 5, this is the addendum. And clause 4 states that those from public, that is why these are the petitioners, lordship. Those from public who want to give representation, suggestion, objection in the hearing are required to submit their representation, suggestions, objection to the concerned CEO, Jila Parishad, Member Secretary, District Delimitation Commission from 18 September 2024. That was subsequently extended, lordship. We have filed our representation suggestions, but those were not disposed of, and instead draft electoral roll was published, lordship.
Mr. Dhor, unregistered association of persons cannot maintain a writ petition.
Lordship, that is there, but those from
We
public.
are concerned with petition number 2. We are concerned with petition number 2.
That is there. That the Bormatia Part 2.
We are not in public interest litigation.
No, Bormatia Part 2 was earlier in Lela Gaon Panchayat.
That we can examine.
Yes, lordship.
That we can examine.
That is what, lordship. Now, arbitrarily,
Since
lordship,
petition number 2 is a resident of Bormotia Part 2, we'll examine that.
that too.
But so far as petition number 1 and 3 are concerned, it is doubtful whether their cases will be examined or not in a writ petition. I'm very clear.
Addendum states that those from public, lordship. That is why these are 1 and 3 is the petition.
Yes, you have a right to file a representation, and they have a duty to dispose of that representation. There is no doubt about it. I don't know whether they have disposed it or not.
No, not yet disposed. That I have stated categorically, lordship.
Now, why it should not be?
Because
Why it should not be in Majakali Gaon Panchayat?
Majakali is around 8 kilometers, more than 8 kilometers distance, and there
Not
is
contiguous.
and yes, lordship.
Not contiguous.
And there is a yes, I have stated in para 3 and 7.
This is the distance.
Para 3 and 7 I have stated, categorically stated, lordship.
Heard Mr. Ardhor, counsel for the petitioners. Mr. King Kaur, Petitioner Advocate General, Assam, and Senior Standing Counsel, Panchayat and Rural Development Department for response number 1, 3, 4, 5, 6.
For 2 while unfamiliar.
5, 6, 7, and 9. Mr. R. Dubey, Standing Counsel, Assam State Election Commission for the response number 2 and 8. Post of 3 petitioners have joined together to institute the instant writ petition. Post of the petition number 1 and the petition number 3 appear to be unregistered association. Post of the petition number 2 has claimed that he is a resident of village Bormotia Part 2. Full stop. The writ petition has been instituted with a grievance that village Bormotia Part 2 entirely with a grievance that village Bormotia Part 2 was earlier within Lela Gaon Panchayat, LELA, and by the impugn notification dated 15/10/2024, village Bormotia Part 2 has been brought within Majakhili, MAJJAKHILI, Gaon Panchayat. Post up. It is a contention of the petitioners that by bringing village Bormotia Part 2 within Majakali Gaon Panchayat. The state respondents have not taken the aspect of continuity, as all the villages surrounding village Bormotia Part 2 fall within different Gaon Panchayats. Okay, issue notice returnable in 4 weeks. As so and so has appeared, accepted. Issuance of formal notice stands dispensed with extra copies within 2 days.
So for Rambuk village is concerned, I'll file separately petition. Okay.
Supplementary list. Item 13.
Met your lordship, but yesterday I think your lordship.
I have
Inspection
to state whether
this.
this.
Previous shorter issue might have one day. Your lordship also dispose some of the cases. madam. That
whether
right?
I have asked them to examine.
We have, in the meanwhile, we have received instruction.
Huh.
Says that it's a clerical mistake. Thanks. Paragraph 6 and 7 even.
4 petitioners here.
Yes.
4 or many?
We have
Five.
given a small-
Five.
That short note also you have given.
5.
Total 5.
Paragraph 6 and 7.
Show it to Mr. Chaudhary also. Para 7. Para 7. Para 7 have been admitted by them to be correct.
If it is corrected, madam, I have nothing to
To be correct, they will do the correction,
Yes, sir.
right?
Yes, madam.
We'll quote para 7
Yes, sir.
and their reply,
Madam,
we'll close it.
6 was also, para 6 is also, madam.
We'll quote para 6,
Yes, and 7.
7 and we'll quote their reply
Yes.
and close it,
Yes,
because 1, 2, 3, 4, 5 sub para.
madam.
Para 7 sub para is sub para 1, 2, 3, 4, 5
Yes.
pertain to 5 petitioners. And they have admitted to be
Yes,
correct.
yeah, but it is what it is, I have nothing, sir.
We'll close then.
Yes, madam. Yes, madam. We are not on the border issue in this case, madam.
Heard.
My lord, Naik, he will be here.
Ah.
And just I am. Hello.
Heard Mr. H.I. Chaudhary, Senior Counsel, assisted by Mr. H.I. Chaudhary, Learned Counsel for the petitioners, and Mr. K. Kaur, Learned. Yes, we can close. K. Kaur, Learned Additional Advocate General Assam, and Senior Standing Counsel of Chat and Rural Development Department for the response number 1.
1, 3, 4, and 6.
1, 3, 4, and 6. And Mr. R. Dubey, Learned Standing Counsel, Assam State Election Commission, for the response number 2 and 5. Full stop. The petitioners, 5 in number, have joined together to prefer this petition. With the primarily with the grievance, as mentioned in paragraph 6 and 7 of the writ petition, in the following manner. The relevant excerpts of the, from paragraph 6 and 7. I think up to subpara 5 will do.
Yes.
Paragraph 7 up to subparagraph. That is 1, 2, 3, 4 petition, all the petitioners. Okay. Ekinle. Para 6 or 7 to quote kori dibo. Up to at a point. Cross kori dibo. Mr. Kumar, Additional Advocate in Assam, has submitted that he has received instructions to pairwise comments. And on the basis of the instructions to pairwise comments, has submitted that the issues raised by the petitioners in aforequoted paragraph 6 and 7 have been examined by the authorities, and after examination, it has been found that the changes have occurred due to clerical errors. Pusto. Para. He has placed the instructions to pairwise comments received from the District Commissioner Hailakandi, provide communication bearing number so and so, dated 19/2/2025, addressed to him. Post up. Para for any reference, the pairwise comments furnished by notification, by office letter will go, sorry. By office letter dated 19/2/2023, are extracted herein below. Page para 6, para 7. Para. Since the respondents would rectify the grievances of the petitioners, if possible, when online electoral roll management system would be reopened. It is observed that the respondent authorities shall do the needful, shall take the necessary steps to rectify the clerical errors, stated to have occurred in respect of the 5 petitioners hearing. First up. With the above observation, the repetition is disposed of. A copy of the office letter number so and so, dated 19/2/2025 of the District Commissioner Hailakandi, is kept with the case record by marking it as document
1 line minute,
X.
1 line minute to various minute. This rectification to be done prior to holding election minute.
And as expeditiously as possible, and in any way of the matter before holding before holding of the election, panchayat election, so that okay, within a period of 2 weeks, within a period of 2 weeks from today.
It must complete a certificate.
A copy of this order is to be furnished to both Mr. Kaur and Mr. Dubey for taking necessary steps from their ends. You will expect that. You also furnish, go there.
For admission, item number 4.
In this matter, we have filed one additional affidavit.
Additional affidavit.
Yes, sir. Yesterday we have filed it.
Is it there or not?
Lordship.
In the record or not? Not there on record. Very difficult then again.
Yesterday only we have filed.
Yes, Mr. Dal, then we can take it up on some other day. On
It is
25th
all the
then.
same, otherwise it is all the same, Lordship, nothing.
No, I have
Yeah.
forgotten, but I'll,
Anyway, Lordship.
then on 25th,
Lordship.
Tuesday,
Lordship.
Tuesday on a hearing day. By that time, all this panchayat will be over. Yes.
All right.
L. Talukdar, Land Council for the petitioner. Mr. B. J. Talukdar, Land Senior Counsel, assisted by Mr. P. K. Medhi, Land Council for respond number 1, 3, and 6. R. M. Das, Land Standing Council, Water Resources Department for the respond number 2 and 5. And Ms. P. R. Mohantal, Land Standing Council, Revenue Department for the respond number 4 are present. Mr. Das, Land Standing Council, Water Resources Department has submitted that
Additional affidavit.
an additional affidavit on behalf of the respondent number 2 and 5 has been filed yesterday. And the said additional affidavit is not tagged with a case record. Full stop. As the said additional affidavit, as the additional affidavit filed on behalf of the respondent number 5. So, stated to have been filed on behalf of the respondent number 2 and 5, is not tagged with a case record. Office to trace out the same and tag the same with the case record. Possibly is the case on Tuesday.
Item 5. May it please your lordship, my lord. My lord, here, my lord, my application for issuance of IMFL.
It
on-
is returnable rate, yes.
Bench.
Bench 4.
My lord.
Why you have mentioned then? Bench 4. Okay. Mr. B. K. Das, Land Council for the petition, and Mr. R. I. Gogoi, Land Standing Council Excise Department have submitted that the subject matter of the petition pertains to bench 4. Full stop. The registry to examine the aspect and thereafter, to list the case before the appropriate bench and in an expeditious manner.
Item number 6. GST cancellation, my lord. No reason was assigned in the order, my lord. No reason was assigned in the order, my lord.
Can we?
Lordship, I pray that coordinate benches pass order. The paragraph 49 may be added to order.
This court has also passed an order.
Praying for adding of that paragraph.
That will not help because that pertains to financial year 24-25, my lord.
Paragraph 49. sir.
Paragraph
49.
But that is 7310,
Yes, sir.
is it not?
Yes, sir. Speak about limitation to be studied.
Huh?
7310.
What about paragraph 26 of my order?
That will cover Lordship, but I pray that this may be added because Lordship, when they will file return, if there is a discrepancy to found that to be notices to be issued within 3 years.
Lordship will see, my lord. The GST was cancelled on 19/4/24, my lord. And this paragraph exclude financial year 24-25. And my case will be fall within 24.
No, let me read it.
My lord.
No, here I have observed with the setting aside of the cancellation of registration order,
Lordship.
two options are available.
There, I'm not disputing that.
That takes care of it. Then again, if his registration gets cancelled, everything is over.
But Lordship, suppose Lordship, we have to calculate 3 years. Like, we have to calculate from the date when they file that.
That is too far for this court to visualize all these things. That will be taken care of. I am saying, page, I think paragraph 26.
Basics, my lord. My lordship's order. It covers.
I have said two options. He can file a reply or he pay all, entire thing, dues,
That is
with
right.
penalty, interest, everything.
Provided in the, and within 30 days, we have to.
That is the, so I put it 1 month from today. I put it 1 month from today. Right, because,
Lordship.
and if he fails, his registration will be again cancelled. I am not, that is too far reaching to visualize everything. Then action will come 73. 73 is short pay, something.
Chief, only because Lordship coordinator has taken into consideration all aspects of the matter. And the director of the department to.
Then I have to read it. I cannot. I have to read it.
This case also Lordship, registration has been revoked, cancellation of registration has been revoked with certain conditions. So,
Don't know.
3. Proviso 3.
So 49 is upon revocation of the cancellation.
Yes, sir.
But I have not,
Yes, sir. That is the.
this is the difference. I have not revoked his
No,
cancellation.
my lord.
I have, but the proceeding I have permitted to continue.
The department can take.
Department, that proceeding will proceed from the stage of show cause notice, I have said.
Yes, sir. You also given to.
Ah. Two options is available. I think because I am not interfering with the
Then also.
show cause notice, because it says at least, because your registration liability cancel return furnished by you under section 39 following failure to furnish returns for a continuous period of 6 months. It is there. And all have been taken care of by the act and the rules. And a person is not supposed to know, he cannot take the plea that I do not know the act and the rules.
No, he cannot take.
So that is not available. So that original show cause notice, I don't find anything to be set aside.
Okay.
This is explained.
Yes, this is okay.
And page 28, there is nothing.
The coordinator judgment, the registration has been revoked.
Huh?
Cancellation has been revoked and they have been given liberty to file return. And the limitation will start from the date when they will file it. So Lordship may pass this out.
Because without reading and in its entirety, if I put it,
No.
because 73 is a far away
Yes, Lordship,
proceeding.
yes. After the restoration that we do.
I have gave you two options.
Yes, yes.
If you file the return, you can pass an order in GST 20. If he decides to file a reply,
Then he can.
Then you proceed. Recording region, yes, cancel again. I have given both the options to you.
No, no,
And if he fails, then you can recover definitely as per this order.
no, that is available in rule 23.
It is there open for you. I am not giving so much
No, no,
reading into the act again.
I think lordship to place this judgment before lordship.
Ah,
That one.
Right. I'll go through it, but same thing, non-application of mind, that is perfunctory manner, that is what it has observed. Okay. Heard. You take your seat then.
Lordship.
Heard, Mr. R.S. Mishra. It order applicable. On the paragraph 1. We'll change the dates only
Fine.
and paragraph if required where it. Paragraph 1. Cancelled by an order dated 19/4/2024. Show cause notice 11/10/2023. Paragraph 2 লিখিব লাগিব, change কৰিব লাগিব। Okay. Messrs B Enterprise. Registration number, page
24, my lord.
24. Paragraph 2, with effect from 9/10/2018.
18.
Paragraph 3. The petitioner was issued the so-called notice dated 11/10/2023 by the proper officer,
My lord.
asking him to show cause as to why the registration certificate issued to him under the CGST Act should not be cancelled due to failure to furnish returns for a continuous period of 6 months in terms of section 39 of the CGST Act. Post of the petitioner was thereby, directed to furnish a reply to the notice within 30 days from the date of service of the show cause notice. Post of. It was, the petitioner was also directed to appear before the proper officer at 11 hours on 8/11/2023. Post of. It was further mentioned that if the petitioner would fail to furnish a reply within the stipulated date, page 27, or fail to appear for personal hearing on the appointed date and time, the case would be decided ex parte on the basis of the available records and on merits. Post of. By the show cause notice, the petitioner's GST registration had also been suspended. WEF 11/10/2023. Post of. Paragraph 4. Thereafter, on 19/4/2024. Cancelled with effect from 19/4/2024. Para 6. R.S. Mishra, SC Kyle. Just to know, this show cause is, it is sufficient notice in the common portal.
Yes.
Um, What is the provision for common portal?
Okay.
142.
Section 169, my lord.
169.
Service of notice. D, my lord, by making it available on common portal.
By any number of following methods. And what is the connected rule?
My lord.
There used to be a corresponding rule everywhere also.
Yes,
That
ma'am.
is why I want to know.
My lord.
Common portal. Maybe 163. Rule one. Not sure. Paragraph 7. Mr. Mishra, learned counsel board of petition has submitted that pursuant to the so-called notice, which was uploaded in a common portal. In terms of section, common portal
169.
169 of the CGST Act, the petitioner could not submit her reply due to reasons beyond her control. Full stop. The petitioner has stated that being not well conversed with the common portal, the show cause notice skipped her notice. And by the time the petitioner came to learn about the show cause notice, the time for filing reply was already over. And the impugn order dated 9/8/2020 had already been uploaded in the common portal. Post of. The petitioner has further stated that at the relevant time, the husband of the petitioner was suffering from various ailments and had undergone a surgery during March 2023. And due to such reasons, the petitioner was preoccupied to look after the medical treatment of her husband. Post op. Moreover, due to not attending the business seriously, the petitioner sustained serious losses in her business, was facing acute financial hardship. Post op. The petition, Mr. Mishra has stated that after recovering from financial hardship, etc., the petitioner updated her GST, submitted her returns up to
Mallet.
April,
April, Mallet, 2024.
April, 2024, as allowed by the GST portal. Full stop. Though the petitioner intended to submit an application for revocation, the GST portal did not allow submission of such application as the timeline of 270 days from the date of cancellation was already over by then. Full stop. Similarly, the petitioner could not prefer an appeal due to expiry of the statutory period of limitation. Full stop. Next subpara, Mr. Mishra has so and so. Date kita change kori bole. Mr. Mishra has submitted that the impugn order of cancellation of GST registration is to be passed in form GST REG 19, and the proper officer while cancelling and assesses GST registration has to assign the regions for cancellation of registration. First off, but the impugn order dated 19/4/2024 is a non-speaking and cryptic one. Post up. Next line to nalage. To 7.1, huh? Para 8, Mr. Cal, huh? Para 9, okay. Para 10, okay. Any typing mistake here regarding the provisions?
No.
11, okay. 12, okay. 13, 14, 15, okay. Reverting back to 16, huh? Date to 19/4/2024. Reverting back to the show cause notice dated 19/4/2024. Issued in the case in hand, it is noticed that the petition was asked to show cause as to why his GST registration shall not be cancelled for non-filing of returns for a continuous period of 6 months and for non-compliance of the provisions contained in Section 39 of the CGST Act. Post of the month since when and the period during which the petitioner did not file the monthly returns were not mentioned in the show cause notice. Post of the petitioner was also directed to furnish a reply to the notice within 30 days from the date of service of the notice. Post of by Next 17. When the contents of the show cause notice dated 19/4/2024 and the contents, not 19/4, 11/10/2023, and the contents of the impugn order dated 19/4/2024 are read together, it is found that No. Found that by the order dated 19/4/2024, the proper officer, while cancelling the GST registration of the petitioner with effect from 19/4/2024, has not assigned any region. Full stop. Eighteen. Dapat nalage. Okay, 18 লিখা by the show notice. Nalage. 18 nalage. 19 to do. 19. 20. 21 not impugn order date to change করিব। 22 লিখব when the contents of the impugn order dated so and so are looked at, it is found that in the impugn order the proposed officer has not assigned any region as to why the petitioner's GST registration has been cancelled. Full stop. Para 23. On perusal of the impugn order, it is evidently clear that the impugn order is not in conformity with the procedure prescribed in Form GST REG 19. The impugn order is not a self-seeking one. Full stop. বা এখানে কি করে দিব খালি ডেট বোর্ড চেঞ্জ করে দিব আলো যে দিয়া আছে ওকে dispose of 1 month from today file your return লাগিব নেক্সট More is available? No. Okay. Petition. None of the parties is, no, there is no representation on behalf of any of the parties on call today on call. There is the case on. Motion that did. 26. Mr. Dub, I to some.
Item number 48.
So exactly, I got to understand how. Exactly, I got to understand. আগৰটো নিচিনা হ'ব আহিলে ৰিস্পন্সিবলি কৈ দিম আৰু নেক্সটটো চাওঁ
Item 49.
এইটো এই অৰ্ডাৰৰ নিচিনা হ'ব এইটো অৰ্ডাৰ একজেক্টলি হ'ব। আহক আহিলে হেৰি কৰি দিম। এটা খালি এপ্ৰুভড ঠাইত কেঞ্চেল বুলি দিছে হা, ৱৰ্ডটো কেঞ্চেল বুলি আছে। Yes, there was one 47, item 47. এইটো একজেক্টলি সেনেকুৱাই হ'ব, এইটোৰ নিচিনা হ'ব দেই। এইটো বসুমতীয়ে মাৰিছে, এইটো বসুমতীক দি দিলোঁ। আৰু এইটো একজেক্টলি মাৰি তাতে কাৰেকশ্যনটো কৰি দিম আৰু। 47, do you have any instructions? Some 47 too.
We have filed affidavit in opposition.
Is it? Okay.
47. In item 47, they have filed affidavit. Affidavit filed day before yesterday. We have to respond it. Some.
You respond then.
Well.
Heard Mr. M.U. Mondal, Learned Counsel for the petitioners, Mr. K. Korn, Learned Additional Advocate General Sum and Senior Standing Counsel, Panchat and Rural Development Department for a response number 1, 2, 4, 6, 7, and 8. Mr. R. Dubey, Learned Standing Counsel, Assam State Election Commission for a response number 3 and 5. So Mr. Mondal has submitted that he has received a copy of the affidavit in opposition filed on behalf
Respondent number 4.
of the respondent number 4. First of he has submitted that the petitioners would respond to the said affidavit in opposition by filing an additional affidavit in reply. And for the purpose of filing affidavit in reply, he has sought for listing of the case after 2 weeks. List the case after 2 weeks.
Can it be after a week?
Huh?
After a week.
After a week.
Obliged. Obliged.
Dispose মানে আহিলে ক'ব পাৰিম থাকক এইটো আহিলে dispose কৰিব লাগিব।
Item 7 for orders.
Lordship, service in this matter is completed, your lordship. Respondent number.
Yes, who appears for respondent number 5? Yes. What is your? Yes, Mr. Sharma, what do you say?
Otherwise, Lordship, your Lordship has indicated earlier that Vinod Kumar's case. By that way, Lordship, we have to send it to the district judge so that it can be decided. That is the, ultimately that will happen, but even that.
Another point you just examine.
Okay.
On the date of the award, the petitioners don't have any
Lordship,
right on the land.
thereafter they have. That
They're
part
not the landowner. Maybe person interested, maybe.
is- Lordship, regarding that, some portion of that land, Lordship,
Hmm.
7 kata 12, chapak, 7 gonda.
Hmm.
Regarding that apportionment, Lordship.
Not basically not apportionment.
But it's a dispute between the two private parties.
Two private parties, not apportionment. The petitioners claim entire amount.
But it cannot be, Lordship, that person has, that is why it is to be
But-
decided.
But respondent number 5, he is the landowner. I think this is a matter to be decided by the principal court of civil
Lordship,
jurisdiction.
That principal court.
What do you say?
Senior instruction.
Who is your senior? Huh? Because this is not to be decided here. This is to be decided by the
Principal.
district judge. We are not here father and son, daughter's dispute.
Lordship.
You are the father of the petitioners. You married for the second time.
Yes, sir.
That is the case.
Yes, sir.
When do you want? There is nothing to be.
She is praying for after 1 week now. 1 week.
MS,
FN Jaman.
Land Council for the petitioner. Mr. R.K. Talabra. Mr. R.K. Dev Chudri. Or who? A Gayon was there earlier. Formal party. R.K. Dev Chudri. Deputy Solicitor General of India for the respondent number 1. R.K. Talukdar, Standing Counsel, NHIDCL for the respondent number 2, and Mr. H. Sharma, and
Three and
City Government Advocate Assam for the respondent number 3 and 4. So Miss P. Odhikari, Learned Council has submitted that she has entered appearance on behalf of the respondent number 5. And the has paid for listing of the case after a week. As the respondent number 5 will file his counter affidavit within a week's time. So the prayer made on behalf of the respondent number 5 is allowed. Lays the case after a week.
Lordship, interim order may be continued.
Lays the case on video category. And the interim order passed shall continue till the next date of this.
I'm deeply obliged, Lordship.
Item number 9 for hearing. Also, in this writ petition, also the petitioner has challenged the election of the respondent number 5 as a ward commissioner of Thekiajoli Municipal Board.
Municipal board,
Yes.
Assam Municipal Act. Yes.
Now, Lordship, as per the statutory
Election.
As per the Municipal Act, Lordship, the statutory period for filing an election petition is 21 days.
Where is that provision?
At page 16,
In a which act? Which act?
Assam Municipal Act 1950.
Municipal government election rules.
In the act itself, Lordship,
When 2022
page 16 of the
is 16.
proceeding to set aside an election.
No, the limitation period.
Yes, that it is there also.
If
Page
the very-
16.
Page 16, proceeding to set aside an election, section,
No, you're referring to
referring to section 16,
section 16,
Plus.
Municipal Act.
Principal Act.
In your book, the word Shillong is appearing.
Shillong is also appearing. Lordship.
Ah, why?
And in case of Shillong and Cell at the same time, yes.
Hmm?
Lordship, although the statutory period is 21 days, we have given sufficient pause. And we could file the appeal finally on 7/7/2020.
Let us read about. When the declaration was made,
Declaration of result was made on 9/3/2022.
9/3/2022.
22.
Where is the declaration of results?
The declaration of result is on 9/3/2022.
9/3.
Lordship.
Hmm. And petition filed when?
Petition Lordship, we finally filed on Lordship 7/7/2022. But before that, Lordship, we have filed repeatedly, Lordship.
Election period. Tell me the date.
Yes, yes, yes. Election petition was filed on 7/7/2022.
7/7.
2022.
Oh, how many days gap? How many days?
March. Almost 4 months. 7/7 count করা আছে 6/9/3 9/3 7.
21. It is reflected in the order at page 17. Well, like.
Hmm. By this order,
By this
this is
order,
the ambient order.
Lordship, by this order, Lordship, my election petition was dismissed on the ground of delay.
Okay, let us read it. Section 16 and 18.
Lordship.
16.
It starts with page 72, Lordship.
18.
Yes.
Okay. And what is rule? 110, 100, 104.
101 and 104.
101 or 110?
101.
Should be 101.
Lordship, I'll check, Lordship.
Rules.
Yes, Lordship. 101, Lordship. 101 and 104.
এই পুরনি আছে নাকি? Purani Municipal Act.
Yes, sir. May I read the imping order?
Hmm.
It starts with page 72. This order appertaining to petition number 2482/2022 filed by the petitioner Ms. Shakti Rani Das under section 16 and 18 of the Assam Municipal Act 1956, read with Rule 110 and Rule 104 in connection with election of Commissioner of Municipal Boards under the Assam Municipal Act 1956, challenging the candidature and return of respondent number 4 from Ward number 10 of Thekiajuli Municipal Board election 2022. And petition number 2483/2022 filed under section 5 of the Delimitation Act seeking condonation of delay in filing the election petition under section 16 and 18 of Assam Municipal Act 1956, read with Rule 110 and Rule 104 in connection with election of Commissioner of Municipal Boards under the Assam Municipal Act 1956. It is contended that the appellant petitioner contested the election of Ward Commissioner from Ward number 10 of the Thekiajuli Municipal Board in the 2022 municipal election as a candidate from Indian National Congress and submitted her candidature by filing nomination on 15/2/2022. And respondent number 4 also submitted her nomination as BJP candidate, showing herself as OBC candidate. After scrutiny of nomination papers on 17/2/2022, the appellant filed complaint before the magistrate in charge, returning officer of Thekiajuli Municipal Board election, challenging the caste certificate and qualification of the respondent number 4, alleging that her nomination papers were false and fabricated one, but returning officer most illegally accepted her nomination. On 19/2/2022, the appellant and president of Thekiajuli Town Block Congress Committee filed complaints before magistrate in charge, returning officer, challenging the caste certificate and qualification of respondent number 4. But the magistrate in charge, returning officer, sit over the matter most arbitrarily and did not take any action on her complaint. Accordingly, election was held on 6/3/2022, and the respondent number 4 was declared successful on 9/3/2022. Even though she was not eligible to contest the election, but having no alternative, the petitioner filed RTI application to State Public Information Officer on 25/3/2022, praying for furnishing all documents of respondent number 4 along with her nomination papers, which was also forwarded to the executive officer, Thekiajuli Municipal Board on 29/3/2022, to furnish documents within stipulated period of 30 days. But after several requests made, petition got the RTI reply from the authority only on 17/6/2022, after 3 months from the date of application. From the reply received, it transpires that the said Srimati Anju Devi had not submitted her educational qualification at the time of filing her nomination papers, and she obtained OBC certificate illegally on 27/12/2009. On inquiry, it was also learned that respondent number 4, Anju Devi, was not a student of Udalguri Girls High Secondary School, and no such student by the name of Anju Devi passed SSLC exam in the year 1997 from Udalguri Girls SS School, which clearly shows that the respondent number 4 submitted fabricated documents which was illegally accepted by magistrate in charge, returning officer, as correct and which is against the rule of law. Respondent number 4 even submitted fraudulent OBC certificate being Giri community, which is a Brahmin upper caste. Even though she was not matriculate, she procured fraudulent documents and contested the election. As per amendment of the Assam Municipal Board Pro Act number 3 of 2019, minimum higher educational gap for class 12 pass has been fixed if candidate belong to SC, ST, OBC, MOBC, etc. But the respondent number 4 did not submit her matriculation certificate with her nomination paper. Instead, filed only OBC certificate in a fraudulent manner. However, the respondent number 3 ignored this vital fact and accepted her nomination, knowing it fully well that respondent number 4 submitted manipulated documents. It is contended that respondent number 4 was not eligible to contest the election in view of the discrepancy of her educational and caste certificate, even though candidate is obliged to make full and honest disclosure, but suppression of it renders the election most illegal and liable to be interfered by this court. In this regard, the appellant also filed FIR in Thekiajuli PS but got no response. Hence this present petition.
After issuing notice, only respondent number 4 appeared through her counsel. Rest did not contest. Land Council appearing for the appellant assiduously contended that election was held on 6/3/2022 and respondent number 4 was declared successful on 9/3/2022 and the appellant preferred the RTI application on 25/3/2022 within period of 21 days from the date of declaration of election result with a prayer to furnish required documents within stipulated time of 30 days. But the documents were furnished to the petitioner only on 17/6/2022, after about 3 months from the date of filing the RTI application. And immediately thereafter, the appellant presented the appeal on 7/7/2022 within the prescribed period from the date of receipt of RTI reply on 17/6/2022. So according to the Land Council, the present appeal has been prepared within time, and this court can well proceed with the case for arriving at a logical conclusion in accordance with law. However, Land Council appearing for the respondent number 4, so, though no written objection has been filed, vociferously contended that the present appeal is liable to be dismissed in limine, as the same has been presented beyond the prescribed period. In election matters, period of limitation under Limitation Act have no application. To substantiate his contention, Land Council has placed reliance on the following judgments. Now, as per Section 16 of the Assam Municipal Act 1956, challenging the validity of election is to be presented before district judge within 21 days after the date of declaration of the result of election in the prescribed manner. In the present case, from the pleadings of the petitioner Shakti Rani Das, it transpired that the election was held on 6/3/2022 and the respondent number 4, Srimati Anju Devi, was declared successful candidate in the election on 9/3/2022, but the petitioner, having been aggrieved, filed RTI application to the State Public Information Officer Sonitpur, Tezpur on 25/3/2022. But RTI reply along with documents have been furnished to the petitioner only on 17/6/2022, after 3 months from the date of RTI application. And as soon as the petitioner received the RTI reply on 17/6/2022, she presented the appeal on 7/7/2022. Therefore, it is the argument of the Land Council for the appellant that the instant appeal has been filed well within time of 21 days as prescribed under Section 16 of the Assam Municipal Act 1956. The contention of the Land Council appearing for the respondent number 4 is that the present election petition is liable to be dismissed on the ground of limitation because, as per mandate of Section 16 of the Assam Municipal Act 1956, election petition has to be presented before the district judge within 21 days from the date of declaration of result. But the appellant has presented the appeal within 121 days from the date of declaration of result on 9/3/2022. According to the Land Council, in election petition, the appellant cannot take advantage of exemption of the period of limitation for filing election petition on the ground of non-filing of reply by the respondent against the RTI application of the appellant against the statutory mandate prescribed under Section 16 of the Assam Municipal Act 1956. In election matters, the appellant cannot take advantage of this when she failed to file the appeal before this court within 21 days from the date of declaration of election result on 9/3/2022. Now, there is a citation referred to. Lordship, may I read the citation or Lordship kindly come to the facts at page 78.
Yes.
Now, coming back to the facts of the present case, it transpires that the contention of the Land Council appearing for the appellant is unsustainable in view of the findings of the Upper Honorable High Court passed in 2014 5 GLR Aslima Khatun versus State of Assam, so and so, wherein it was specifically held that the election rule is a special rule, which is a complete code in itself. The election rule does not make any provision to make the Limitation Act applicable to the election rules. In the present case, Section 16 of Assam Municipal Act 1956 specifically prescribes 21 days for preparing appeal by aggrieved party from the date of declaration of results. But as it appears, the appellant missed this opportunity and therefore filed petition number 2483 of 2020 under Section 5 of Limitation Act, seeking condonation of delay in filing the election petition on the ground that appellant petitioner filed RTI application on 25/3/2022 and the reply has been received on 17/6/2022. That is after 3 months from the date of RTI application, and the appeal has been presented on 7/7/2022, well within time from the date of receipt of RTI reply on 17/6/2022. However, the contention of the Land Council for the appellant to exclude the period in getting the RTI reply for the purpose of preparing appeal under Section 16 of the Assam Municipal Act 1956 cannot be accepted merely because Section 104A proviso of the rules of the election of Assam Municipal Act 1956 provides that for the purpose of completing the period of limitation to the provision of section 4, 9, and 12 of Limitation Act 1908 shall apply mutatis mutandis in view of the findings of the Honorable High Court in 2014-5 GLR Aslima Khatun versus State of Assam. In view of the foregoing discussion and reason, this court does not find any merit in the application appeal. Consequently, the applicant stands dismissed.
Yes,
Lordship, from the RTI reply, it is very evident, Lordship, that she did not, as per the notification dated 9/2022, she did not submit her HSLC mark sheet.
no,
And
that,
only made a
we
declaration
are on the
and
point of
post-
limitation.
Limitation.
We cannot go
Yes.
into that because the petition has been rejected on the ground of limitation.
Limitation. Yes.
Now, 104A speaks about section 4, 9, and 12. And does not refer to any other thing limitation. So how can it be considered?
Okay, may I place two judgments? Actually. কৈলাস উদাসীন করে। Yeah. Lordship, I would like to place a few small paragraphs, Lordship, of some decision, Lordship.
Yes.
2005 4 SSC 480 Lordship, paragraph 28. All the rules of procedure are the handmaid of justice. The language employed by the draftsman of procedural law may be liberal or stringent, but the fact remains that the object of prescribing procedure is to advance the cause of justice. In an adversarial system, no party should ordinarily be denied the opportunity of participating in the process of justice dispensation. Lordship, may skip then. Lordship, the procedural law so dominates in certain system as to overpower substantive rights and substantial justice. The humanist rule that procedure should be the handmaid, not the mistress of legal justice, compels consideration of vesting a residuary power in judges to act ex debito justice, where the tragic sequel otherwise would be wholly inequitable. Justice is the goal of jurisprudence, procedural as such as substantial. Next one is Lordship, 2006 1 SSC, page 75 also. Paragraph 17 was.
Paragraph
Paragraph 17.
7.
17, 1 7. Non-compliance with any procedural requirement relating to a pleading, memorandum of appeal or application or petition for relief should not entail automatic dismissal or rejection unless the relevant statute or rule so mandates. Procedural defects and irregularities which are curable should not be allowed to defeat substantive rights or to cause injustice. Procedure, a handmaiden of to justice, should never be made a tool to deny justice or perpetuate injustice by any oppressive or punitive use. Then also the principles has been given.
Yes.
The next one is 2009-13 SSC, case 25. Paragraph 12. If bringing on record a document is essential for proving the case by a party, ordinarily the same should not be refused. The court's duty being to find out the truth. The procedural mechanics necessary to arrive at a just decision must be encouraged.
Hmm.
We are not unmindful of the fact that the court in the said process would not encourage any fishing inquiry. It would also not assist the party in procuring a document which he should have himself filed.
Yes.
Then there's our Honorable High Court's order, Lordship, Abdul Aziz. In this case also, Lordship, that period of limitation was, Lordship,
Para.
paragraph 14. The next question that arises for consideration is as to whether ground cited in the application for continuation of delay can be construed as sufficient cause within the meaning of Section 5 of the Limitation Act. At the outset, it must be noted that the appellants before the learned lower appellate court filed the appeal without any further delay after they profess to have come to know about the judgment and decree of the learned trial court. Defendant number 1 was also not an appellant before the learned lower appellate court. It is also to be emphasized that no objection was filed to the application for condonation of delay. The learned lower appellate court found fault with the appellants for not taking steps individually and not keeping back of the suit. While ideally parties to the proceedings should take steps independently, this court cannot gloss over of the fact that in the village areas, one of the parties are generally entrusted with taking of day-to-day steps. There is no denial to the averments made in the application that the appellants are illiterate, rustic people, or that the plea taken by them is false. The expression sufficient cause in Section 5 of the limitation must receive liberal construction. In the attendant facts and circumstances of the case, it cannot be said there was gross negligence or deliberate inaction or lack of bona fide on the part of the appellants in approaching the court after expiry of the period of limitation. In view of the above discussion, I am of the considered opinion that this appeal deserves to be allowed. Accordingly, the impugn judgment and decree of the learned lower appellate court is set aside. Delay in preparing the appeal is condoned and the lower appellate court is directed to dispose of the appeal on merits. Substantial question of laws are answered accordingly in the light of the above.
All these are general laws.
General laws.
Now, tell me, this is a special law, special limitation period is provided in Section 16. And nothing specific regarding condonation of delay.
One judgment also have places with regard to election petition. And this,
because the general principle may not prevail over special law. And it has made it specific by the provision of Rule 104A that only 4, 9, 12 will apply. 9 counting of days. How to count days? What is 12? Exclusion of time in legal proceeding. And 4, expiry of prescribed period when court is closed. Only 3 provisions of the Limitation Act.
Yeah.
And by operation of Section 29, subsection 2, if it is a special law, then that will apply. If the by operation of 29(2), Limitation Act is excluded, save and accept few provisions of Limitation Act, meaning thereby the other provisions have been excluded. Meaning thereby section 5 is excluded.
Lordship, the 2005 4 SCC which I have placed, that is pertaining to special
2000
5 4 SCC 480. Koilas.
is CPC. Koilas is famous for CPC written statement perhaps. 90 days. Koilas versus Rangpu. There is nothing but CPC.
Yes.
General law.
That much I have.
Yes.
Lordship, I'm for the big, respondent number 5, Lordship.
5.
We have 5 our objection, Lordship. Lordship, in our objection, we have stated in paragraph 10, Lordship, regarding limitation.
Paragraph
10, Lordship. Maybe, sir.
Response number 5. That is already reflected in the order, impugn order.
Because there is a delay on 15 days, the declaration of result. And relying the citation Lordship 2018, Aparna Das is clearly reflected that in paragraph 24. May I read that?
You have a copy?
Yes, Lordship. A perusal of the board scheme of the election rule, which is already noticed at paragraph 9 of this judgment, leaves no manner of doubt that election rules is a special rule, which is a complete rule in itself containing period of limitation in Rule 78 for filing election petition. Any matter which is not covered is to be guided by the provision of the Representation of People Act 1951. The Supreme Court in K. Venkateswar Rao and Hukumdev Narayan Yadav has held that Limitation Act is not applicable to the Representation of People Act 1951. The election rules does not make any provision to make the Limitation Act applicable to the election rules. An analysis of the different provisions of the election rules will indicate that the provision of the Limitation Act do not expressly excluded by necessary implication excluded. In view of above discussion, I have no hesitation to hold that the learned district judge Kokrajar acted without jurisdiction in applying section 5 of the Limitation Act with section 151 CPC to condone the delay in filing the election petition by the respondent. So it's clearly barred.
What about 104A? Rule 104A. What will be the interpretation?
Now, Lordship, there is one more, some Municipal Corporation Act 2022, which is all, which has been applied in Silchar. Lordship, as per this Corporation Act, Lordship, the limitation period is 45 days.
No, that will come to your rescue. That I have seen. New Act has come in November 2022. I have already seen.
Yes.
It has been in.
Your election petition will be governed by the rules
Yes.
that was in existence at that point of
At that
time.
point of-
And what is the meaning of this? Muted this. 20 Aslima Khatun. 2014 5 GLR. Is it available somewhere? Aslima Khatun. This is Aslima Khatun. Or Pona. 1 minute. Have it. This is regarding what?
Lordship, in judgment,
This is Boroland. Boroland territory rules.
Aslima Khatun is
1 minute. Whether because of 104A, Section 4, Section 9, and Section 12 of the Limitation Acts are made applicable, whether that would bring some difference. Because in Assam Panchayat Act, Aslima Khatun is Assam Panchayat Act. Where it is clearly made specific that Representation of People's Act would be applicable. Itu নহয়. Itu বেলেগ বেলেগ বড়ো, এইটো বেলেগ, এইটো বেলেগ, এইটো বেলেগ, এইটো বেলেগ এনেকে। In Aslima, it was dealt with Panchayat Act, where Representation of People's Act have been made applicable, and that is why Limitation Act is ousted. But here, in the Municipal Act, there is a specific mention of certain provisions of the Limitation Act in 104A, and that is regarding this presentation of election petition. Every contains are necessarily signed by the petitioner. The petitioner may in addition in every appeal. Second provision.
Regarding three sections.
Hmm.
Section 5 will not come.
How Section 29 is to be interpreted then?
It is having blood. With this by incorporation in view of Rule 24A. With this three section that will get applicable. See.
I've seen.
Only as regard not nomination.
Validity of such election shall not be questioned in any such petition. The ground and name of the new person qualified to vote must be omitted from the electoral roll. The ground and name of the person must qualify to vote has been declared in the ground on the ground of acceptance or refusal of nomination of candidates. Provided further that appeal in a manner shall align to his acceptance of nomination. Hmm.
That would be at a stage when nomination was refused or accepted. In that case, we would-
Whether that provision is available or not for appeal?
Yes, yes.
Where is the provision? No, proviso C, meaning thereby there should be some more appeal, provision for appeal.
This really would
If
be-
we read section C, provided further the validity of such elections shall not be questioned in any such petition. Because the nominal heading is proceeding to set aside an election, right? So provided further that the validity of such elections shall not be questioned in any such petition on the ground of acceptance or refusal of nomination of candidates.
Again, provided-
Then again provided further that appeal in the manner prescribed shall lie to the district judge against such acceptance or refusal of nomination. Right. So whether any period or limitation is there.
As far as 16 is concerned,
Section 16 substantive part is
that's the final.
if the validity of an election of a commissioner. So that is one part. There is another part, I think that is the third proviso perhaps, where it says, provided further that an appeal in the manner prescribed shall lie to the district judge against such acceptance or refusal of nomination. Right. Now let us see again 104.
There will be-
Why then this 104A?
Because when petition is filed, we generally.
Let us read 104A. Every appeal under clause C. Oh, that is another 7 days. There is another catch. So you had the option of acceptance nomination. You could have preferred an appeal before the district judge. Response number 4 appeal of nomination acceptance should be set aside. for that 7 days period that you could not avail, or you did not avail, or you failed to avail. Then declaration. Declaration requests 21, provides 21 days. So once that you did not prefer that appeal,
That's it.
That's
that is gone.
Because for filing of rejection or application, one has to apply for the certified copy of it. That's why.
Yes, section 12, section 9 is counting of days. How the
Yes.
period is to be counted, the date of cause of action is to be excluded, last date is to be included. That is one. Section 4 is different. Section 4 is, I think, when court is closed. If Sunday, Monday. And 12, not certified, not certified copy. Legal proceeding. In computing, suppose he has filed it before district judge Sibsagar, or maybe subdivisional magistrate, whatever. In computing, the period is the day from which such period is to be reckoned shall be excluded. That is correct. If for an appeal or an application for leave to appeal for revision, the day on which a judgment complaint was pronounced and the time requisite certified copy, then so meaning that these are specifically included. As a corollary, the other provisions have been excluded, and other provisions include section 5.
You could have filed it only after receiving the information through RTI.
That is a different, but you could have,
So
if
that-
you are so sure about it, you could have filed the petition. You had doubt. If you had been so sure, yes, that lady does not have the qualification of matriculation and has obtained a caste certificate fraudulently. If you are so sure, you should have filed it, because that can be proved by witnesses and calling records.
Instead of filing the election petition,
Because-
she filed a complaint, FIR, then lodged the RTI application. That procedure.
That collection of documents, that will not give you what to do. That too, we'll keep it part on Thursday, we'll dispose of. Because that too, again, election petition.
That limitation was filed on the 61st day. 1 day.
No, in one, say 29(2), there is a specific reference here.
Like special acts, not like 2013 act.
Hmm.
That was the rehabilitation.
And this also, this kind of delay cannot be condoned by this court under 226 and cannot be condoned by Supreme Court under 32, and also exercising their extraordinary power under Article 142 also.
But Lordship, there is no provision in the act for filing further appeal.
End of the
So,
matter.
so petitioner cannot be
End.
remediless.
End of the matter.
Petitioner cannot be remediless. Lordship.
No, that's
He had a remedy, but he lost it.
lost. There is one more famous sentence. That one, forgotten. By the act of limitation, your right to seek remedy is closed, but right to something is still alive, but you are meaning thereby you are remedial. Okay, hard. Yes, Mr. Sharma, anything? You're a party? Okay. I heard urban development, you represent.
Because I'm appearing on behalf of
Response number? 4. 4.
Yes.
Okay. Heard Mr. S.K. Das, Learning Council for the petitioner. Mr. H. Sharma, Learned Additional Senior Government Advocate, Assam, for the response number 1 and 3. Mr. R. Dubey, Learned Standing Council, Assam State Election Commission, for the response number 2. Mr. B. Burang, Learned Council for the response number 4. And Mr. P. Bora, Learned Council for the response number 5. Post of as the hearing. I'll dictate the order on Thursday. As the hearing remained inconclusive today, raise the case on Thursday as part heard.
All right.
Yes, Mr. Where is Dr. Gogoi? Call him at 2. We'll dispose of your matter. It 2, response number 5. এখন কিতাপখন কাৰ আছে ন? আমাৰে?
Item 48.
Okay, we'll dispose of.
Rule 22C. Both the cases.
In both the cases.
Same. Lordship has already passed an order on the ground of that. Only one point, sir, if they give all the penalties.
Take
Because
some
it will-
interest penalty.
And everything in interest,
If any outstanding is there, then we clear it.
late fee. Okay, penalty if any.
Deeply.
Development.
Highly obliged.
It was বসুমতে মাৰি দিব।
Items
What will be your-
15 to 46.
এইটো এটা মন্তব্য কৰিব লাগে। এই এটা মাছের পজিশন নাস্তিক ফুল আৰু এটা আছে নেকি? Yes.
He is coming, you know, he's a good number 2.
অবজেক্ট নালাগে নালাগে এতিয়া নালাগে লাগিলে মাতি আছে ন Mr. Kaur, where have you filed a comprehensive affidavit?
Your Lordship, WPC number 5346. Sir.
Okay.
Item number 15. You
Itu Jairos করে পেলেন, ওটা ডিডি করে।
In item number 15, Your Lordship.
Okay.
We have only, on law point, we have filed a affidavit. Page 197.
Please, মারি পেলে খুঁজি বলো।
Lordship would kindly take WPC 5346
Yes.
and also 48. Let me start with 48 because it was argued yesterday by learned senior counsel AC Borpora. Nagorik. An NGO has filed its writ petition, whether the writ petition in its present form can be considered by this honorable court. Very bulky petition.
Yes.
But it deserves dismissal in limine. That the WPC 48 of 2025, Nagorik Odhikar Purokha Monsa and another. Lordship will kindly come in the first round during the interim consideration also. We went and placed this case. Lordship will kindly come to page 9. The petitioners are citizens and permanent resident of the addresses shown in the clause title. As such, they are entitled to all rights, protection, and privileges guaranteed to the citizen of the Constitution of India and other statutory laws them thereunder. The petitioners are the local social activists and permanent residents of Sri Bhumi, Karimganj district of Assam, and are small businessmen by profession. The petitioner number 1 is the president of Nagorik Odhikar Suraksha Mancha, and petitioner number 2 is the secretary of Nagorik Odhikar Suraksha Mancha. This Nagorik Suraksha Mancha is formed on 14 December 2020. Lordship will kindly mark this. Consisting of the permanent residents voters of Kalchan Gaon Panchayat, erstwhile Masli Gaon Panchayat area, and its neighboring area of Lajamurjar, etc., situated in the delimited number 123 Karimganj North Legislative Assembly constituency of Sri Bhumi. It is a non-government organization newly formed to take appropriate democratic legal measures against extremely illegal, illogical, irrational, and then final delimitation on Karimganj district, particularly in number 123 Karimganj North LSC, more particularly in the Kalachan, Lajamjwar, and Mahakal Gaon Panchayat constituency. All the adult persons of the Gaon Panchayat, namely Kalachan, Lajamur, and Mahakal area and its adjoining are general members of the NGO, automatically by virtue of being residents of the area and its surrounding, if not otherwise excluded specifically for any valid reason. The NGO of its own has no political agenda or inclination towards any political party The only agenda of this NGO is to take all possible necessary democratically as well as legally against the unacceptable, grossly illegal, total unreasonable, illogical and irrational panchayat delimitation made by the Karimganj District Delimitation Commission. As such, the petitioners have and are entitled to file the instant writ petition before this honorable court for the redressal of the genuine cause and against violation of the rights of the people of their locality and of their own as guaranteed by the Constitution of India. Translated copy of the resolution Annexure A, Lordship will kindly see. Annexure A. Page 55. General meeting of the so-and-so. Signatures of all in the meeting 1 to 269. And they have given the signatures also 269 persons. So this page 55L, date is 14/12/2024.
14.
From their own statement, it is very clear that all the citizens of that particular LSC or the panchayat are members and they want to agitate before this honorable court on the issue of delimitation that has conducted in the district of Karimganj. First thing what I would like to highlight is the date of their formation, that is 14/12/2024. Number one. And also the name of the petitioner, page 7, clause title, in the matter of Nagorik Udhikar Puraksha Monsha, represented by its president, Jiaur Rahman, age 40. And number 2, Nagorik Udhikar Suraksha Monsha, represented by its secretary, Nijamuddin. So, no individual has come before this honorable court. Very clearly, it is evident. Next is that if we look at the whole paragraph, there is no indication that this NGO is a registered one. So it is an unregistered non-government organization. Page 14, Lordship will kindly see. Paragraph 6. The petitioners state, petitioners with 1 and 2. State that after publication of the draft limitation notification, the petitioners and many others have approached the district delimitation commission, raising genuine grievances, both verbal and in writing. They and many other local people submitted written objections in respect. That means 1 and 2. In respect of the draft delimitation and notification of the Gaon Panchayat, including some rough sketch maps showing utterly irrational, etc. Very unfortunately, the respondent commission outrightly, sometime very rudely rejected the request to put their seal below their signatures, acknowledging the receipt of supplement. But the district delimitation committee did not consider nor applied its mind on genuine grievances, objections, etc. If Lordship is pleased to now come to that notification where the timeline is given, that notification they have annexed at page 60. Yes. This addendum, Lordship will kindly mark the date, which is in the next page, that is 5th September 2024. 5/9/2024. This addendum, in continuation of this department earlier notification of 3/8/2024 regarding standard operating procedures for Gaon Panchayats, Anshalik Panchayats and Jilla Parishads, the Governor of Assam is pleased to incorporate the following points. Date of publication of the draft delimitation notification 27 September. Sorry, may I just read it? The date of publication of draft delimitation notified by the District Delimitation Commission is hereby extended by 10 days up to 17 September. That is first date. The final notification will be issued on 27 September 2024. The following guidelines are notified in addition to the guideline issued earlier regarding the public hearing after the publication of the draft delimitation notification. The first notification was of 3/8/2024. And this is an addendum where further extension has been granted and a specific date has been given that the final notification will be issued on 27 September 2024. And next page, Lordship will see the timeline for hearing, Roman 10. Timeline for hearing shall be as follows: 18 to 28 September 2024, that is submission of representations by individuals, civil society, organization. By 19 September, meeting with all the recognized political parties. 22nd September, sorting and scrutinizing of the representations, suggestions, objections, schedule hearing dates, and issue notification for the same. 23rd to 25th, conduct hearings at district level LSCs for individuals, organizations, keeping separate dates for individuals and organizations respectively. 26 September, work on modifications, if any. 27 September, final notification. The story ended on 27 September. And this particular writ petitioner number 1 and 2 was born on 14th of December after 3 months. So their statement at paragraph 6 that the petitioner stated after publication of the draft delimitation notification, the petitioner and many others have approached the District Delimitation Commission, raising genuine grievance both verbal and in writing. So when they were not born in the month of September, how can they have represented before the District Delimitation Commission? So prima facie, this is a perjury they have committed before this honorable court. They are playing with the honorable court by stating on oath. If Lordship is pleased to look at affidavit, what they have said about paragraph 6. That affidavit Lordship will find at page 54. So paragraph 6, knowledge and I believe to be true and the statements made in paragraph 1 to 6, etc. are matters of record. So paragraph 6, what they have stated as per their affidavit at page 54, these are part of records. Now let them produce the record. Where this Nagorik Purokha Monso, Nagorik Odhikar Purokha Monso has submitted their representation. It should be on record. So they are telling lies or incorrect facts before this honorable court again and again. An exemplary cost may be imposed on this kind of petitioners. I do not want to go beyond that whether they have genuine rights, etc. I will place the law. What is the law relating to an NGO which is unregistered so far as filing of writ proceeding is concerned? Had it been a PIL, the issue would have been different. If they had come individually, the issue would have been different. But when in the garb of an NGO, petitioner number 1 and 2, both are represented by their president and their secretary, same organization, which is also quite uncommon. And on top of that, when the whole exercise of issue of notification regarding the Gaon Panchayat, calling for objections, hearings, then final notification, everything had taken place in the month of September. They evolved in the month of December, just before the Christmas Eve. On 14th of December, they were born. And now they are raising this honorable court, all these issues, and arguing day after another. After their closing also, they wanted and argued yesterday. So this is the conduct. If Lordship allows me, what is the law? So beyond this, I do not want to go with their petitions because it does not deserve any kind of response from our side. Because it is very clear, without any doubt, from their own records, prima facie, and Lordship may draw a conclusion also, It is as clear as the fact when there is no dispute at all. Their own statement that on 14 December they were born. So all the submissions of the senior counsel AC Borbora may not be considered by this honorable court, because in this kind of cases where the issue of maintainability and locus is challenged, the honorable court normally decides whether the honorable court will further go and decide the case on merit or not. So my humble submission is that the law has been well laid by the division bench of this honorable court, which is reported in 2007 3 GLR 805. Justice Salameshwar and T. Nanda Kumar Judge, they were the division bench. Rangapara Development Circle versus State of Assam and others. In PIL number 30/2007, it was at least on a better footing. That agency has come, that NGO had come and filed a PIL. No personal right was here. By referring to several cases, the honorable court decided in paragraph 4 and 5 and laid down the law. Admittedly, the petitioner NGO is an unregistered association, and therefore petitioner NGO is not a juristic person. It is well settled law that writ petition filed by the unregistered association is not maintainable. Reference may be made to the decisions of this court in Nursing Minibus Owners Syndicate and another versus State of Tripura. Citation is given. All Manipur DIC Supervisors Association versus State of Manipur and others. Citation is given. State of Manipur and others versus State of Land Use Board Casual Employees Association. In all these cases, the law is well settled, reiterated by the division bench. The present writ petition filed by the NGO for enforcing the directive principles of the state policy under the Constitution of India is not maintainable. We are of the considered view that the present writ petition is liable to be dismissed on this score. I am having the same prayer here also. It is elementary that no one can ask for a mandamus without a legal right. There must be a judicially enforceable right as well as a legally protected right before one suffering a legal grievance can ask for a mandamus. A person can be said to be aggrieved only when a person is denied a legal right by someone who has the legal duty to do so or to abstain from doing something. The apex court in Mani Subrat Jain versus State of Haryana, 1977 2 SCR 36, held that no one can ask for a mandamus without a legal right. In the present case, the petitioner NGO has utterly failed to show that the petitioner NGO has acquired the legal right for seeking the relief sought for in the present writ petition. Hence, the present writ petition is not maintainable. Taking a cue from this ratio, Lord, my submission is that this particular NGO does not have a voting right. What is this all about? Constitution of Panchayat at the level of Gaon Panchayat, Anchalik Panchayat, Jilla Parishad, for that delimitation exercise is done. These are only for the purpose of having a PRI institute, that is public Panchayati Raj Institute in place. And for that, an election has to take place. For that election, there will be voters. Electoral roll has to be prepared. Constituency has to be demarcated. For that purpose, delimitation exercise is done so that which are the Gaon Panchayat, what will be the voter list, electoral roll, etc. And in that, only individual persons, their name will be entered. It is not the electoral roll will not have any NGO, whether it is registered or unregistered, in their electoral roll. The NGO on its own does not have any legal right to vote in a election, whether it is a Panchayat election or other elections of the country. So my humble submission is that this NGO does not have any legal right which can be enforced by invoking the jurisdiction of this honorable court by filing of this writ petition. They can, like other writ petitioners, I am not raising this issue. Only in case of the NGO, this specific submission is there. I have another judgment of the Supreme Court, Mani Subrat Jain, which was referred here versus State of Haryana. second page, Lordship will come to the last paragraph. The High Court, Lordship got it. The High Court rightly dismissed the petition. It is elementary, though it is to be restated that no one can ask for a mandamus without a legal right. There must be a judicially enforceable right as well as a legally protected right before one suffering a legal grievance can ask for a mandamus. A person can be said to be aggrieved only when a person is denied a legal right by someone who has a legal duty to do something or to abstain from doing something. Halsbury's law is so and so, state of etc. So my humble submission is that, Lordship, this NGO does not have any legal right to be a part of the election process. So in that view of the matter, filing of a writ petition by an NGO is not maintainable so far as it is a case of election or delimitation to that effect. All the submissions in my humble submission does not deserve any response from my side at this stage. If finally Lordship decides this individual case and decides that this is maintainable, then definitely Lordship may be pleased to give me the right to respond. I am addressing the other arguments of the other councils.
In essence, what Mr. Barbara has said, it is a reiteration of.
I understand, Lordship, but I have to demarcate so that his argument, which I have not heard yet, said deliberately, because I had another case that is a different. But Lordship, whatever argument he has made, we have noted all the submissions made by the other councils. To that we'll respond. Yesterday's arguments we have not noted down because prima facie it is a open and shut case that it deserves dismissal, and that bulky petition does not deserve any perusal also. Now coming to the whole exercise of delimitation in Assam, why it has to be done. Lordship knows, in fact, last Monday, the Honorable Supreme Court passed an order in the ongoing proceedings in the Supreme Court from 2020 onwards, when there is a presidential notification that there is a substantial delay in going for the delimitation exercise in northeastern states and J&K. In northeastern, it is Manipur, Arunachal, Nagaland, and Assam, and J&K. With that notification, a delimitation commission was constituted with one of the Honorable Supreme Court judges, and that exercise was undertaken in Assam. Before the last year's general election, so far as Lok Sabha is concerned, Lordship, the delimitation exercise was completed sometime in the month of December 2023, August 23, and some of the persons were aggrieved and went to the Honorable Supreme Court. And Honorable Supreme Court, Lordship, in the interim order, because our whole foundation is the whole basis and foundation of the present exercise is the election commission's delimitation exercise for the assembly as well as the Lok Sabha constituencies. So I'll come to that in the SOP. The reference is at the first paragraph itself. This case, Hirendranath Gohai,
It is already.
Union of
Yes.
India.
Hi.
I have Lordship have got it. Yes. So here, after completion of the exercise, so far as State Assembly and Lok Sabha constituencies were concerned, Lordship, they have challenged various provisions of the Act, also Section 8A, etc., including the whole exercise. And one of the grounds is identical, which is being agitated here also, that is the population ratio part. If Lordship is pleased to take that judgment, Kapil Sibbal's submission. Yes. Lordship will kindly come to paragraph 8. The challenge which has been urged on behalf of the petitioners by Mr. Kapil Sibbal's senior counsel can be formulated as follows. Roman 3. Article 172, sub-article 2 of the Constitution indicates that each state shall be divided into territorial constituencies in such manner that the ratio between the population of each constituency and the number of seats allotted to it shall, so far as practicable, identical parameter provision is for the panchayat also, be the same throughout the state. Similar provisions are embodied in Article 81(2). In the present case, the draft proposal which has been published by the Election Commission proceeds on density of the population and in doing so breaches the constitutional norms which are prescribed in the above provisions. So that is one of the main plank of the challenge. The Honorable Supreme Court in paragraph 12 says, notice whereas, etc. The process of delimitation has commenced following the decision to resign the deferment of the delimitation exercise for the state of Assam on 28th February 2020. Section 8A of the RP Act makes a special provisions for 4 states, namely the states of Arunachal, Assam, Manipur, and Nagaland. For these 4 states, upon the rescission of the deferment order, the conduct of the delimitation exercise is entrusted to the Election Commission. The provisions of Section 8A contain detailed specification in regard to the manner in which the Election Commission is to carry out the delimitation exercise. The process has commenced following the notification dated 28 February 2020. The draft proposal has been published on 28 June 2023. It would not be identically here in September we issued it, and on December 28th the final electoral rolls were issued in the present case. It would not be appropriate to interdict the process at this stage. Hence, while reserving the constitutional challenge that has been addressed before the court to further deliberation, we do not interdict the Election Commission from taking any further steps. On the basis of this order, Lordship, the Lok Sabha election had taken place in April and May last year in Assam.
And
Now-
this order is 24 July 2023.
Lordship.
And Election Commission final notification came in August.
Lordship.
And whether that is challenged in any manner?
So they have conducted they have raised this objection on the whole process, including one of the provisions of the RP Act also. In any case, last Monday, I could not get the order, but newspaper publication, Lordship, I'm trying to get.
Assam is complete.
Delimitation, Supreme Court sets deadline for center to complete the delimitation exercise by June. This, may I just read this? I have Lordship got it, the second page.
I read it in today's Times of India.
Yes, the
In a-
newspaper, because we try to get the order also, it is not uploaded.
In a more elaborate way, it is said that Assam is complete.
The Supreme Court on Monday granted the central government 3 months to complete the delimitation exercise in Arunachal, Nagaland, and Manipur and Assam, following repeated delays in implementing the process. Subsequently, it has been written Assam has already completed also. So Supreme Court has also given the final stamp. So there is no uncertainty on the delimitation exercise done by the Election Commission of India in respect of the state legislative assemblies as well as the state Lok Sabha constituencies. Now, if we go,
That challenge remains, constitutional challenge remains.
that remains, but when the Supreme Court says completed, that means Supreme Court will not play with that direction that you complete it by June and on September we are going to set aside it. This is a huge exercise. And in Assam, it is pending for last 15 years, maybe more than that. Because of the various law and order situations, not only in Assam, Nagaland, Arunachal, Manipur, including GNK. That is why from the rest of the country, we were segregated because the law and order situation in other parts of the country were perfect for delimitation exercise. In Assam and the other 4 states, there was some difficulty, and that was precisely the reason when the state government in 2007 laid down the position before the court that there should be a deferment of this exercise because the law and order situation was not perfect or supportive of this exercise. So my submission would be that as the Supreme Court has already given a green signal for this exercise to be completed, which was not complete. In fact, it was completed to a certain extent. And also when this honorable court's order was passed at the interim stage, at that point of time, no election was conducted on the basis of the new electoral roll and the delimited constituencies. That was subsequently done within 6 months of the passing of that order. Now, let us go to the SOP. Page 32 of the affidavit we have filed. Now, in the writ petition of Ashraf Kalam Azad Laskar 5346, that writ petition.
I have done.
Lordship. The SOP, may I place it? Before starting my SOP, Lordship, till now, nobody is aggrieved by this SOP. There is not a single challenge. Not a single challenge of this SOP. And it has been already acted upon without any grievance from any quarters. By the orders of the governor.
Challenge means
This SOP, whatever is there, nobody has been aggrieved by any of the conditions laid down in the SOP. So it is not put to challenge. What they are challenging, they are individual villages, because I'll come to that little bit later. What exactly is the grievance? In some, the grievance is that my office will be little bit far away from my residence. The Gaon Panchayat office is far away from my residence. That is one ground. Just like my residence and the distance of the proposed High Court shifting area, that can be a ground. These are the identical cases.
Well, I have put the question just to, they have some pictorial depiction that I have said, rebutted, that just because today capital of Assam will be shifted to, say, Silchar, the person from Dibrugarh or person from Dhubri cannot agitate that.
Yes.
That is a different issue. But another contention is that, suppose my Ulubari is a village, and the other areas are near Maligaon, and it is standalone village which is separated from other wards or other villages like that. That is another contention. We'll come to that later on.
Now, that is not the case. In fact, we have verified from various facts. That is not the case. But if we look at Pondicherry, the state of Pondicherry, in 4 parts, Pondicherry is situated. One part is near Hyderabad, one part is near Lakshadweep, one part is beyond Tamil Nadu, and one part is that Pondicherry where Auroville is situated. A state can have 4 different areas in different parts. I'm just giving an analogy, that a state can be bifurcated into 4 different land masses, and when there is other areas in between.
It could be.
It could be.
Yes.
These are all
when
blocks.
Pakistan and East Pakistan was there.
Yes.
There was
India
a
was
nation.
in between. Lordship is giving a better example than my.
Anyway, that is a different.
Dima Hassan, BTR. BTR, some areas are near Lakhimpur now. There is the Assam in between. Missing autonomous council in various pockets of the state. Rabha Assam, same. But that is not the case. Still, that is not the case. Here, the case is very interesting. That I was a member or president of the earlier Gaon Panchayat. With the new Panchayat, I cannot become the president. Very flimsy and very interesting grounds. All political.
What are the rights involved? Nobody has addressed this point. What is the right? Right to vote. One. And right to stand in election. What kind of right?
Yes,
these are
2 different rights.
All right. That is why I am asking.
Yes.
Right to vote is what?
Yes.
Fundamental right.
Right to contest is another.
Right.
But none of the rights were deprived in the present case. That is why they are not arguing. I am not suppose Lordship is in Ulubari and Lordship is now having your Lordship's name in Bhangagarh's Lok Sabha constituency. Suppose, for example, Lordship will still have a right to vote. That right is not taken away. Instead of Ulubari, Lordship will vote at Bhangagar. That is
That
one.
is why I am,
Yes.
I put the question.
And
I put the question whether right to vote is violated.
No.
That is not
Not
otherwise addressed. And some may be political experience
Yes.
also.
in this
So-
voting, he does not have a chance.
His voters are,
Gone to a different constituency.
maybe that could be a situation. Right to contest election is what? Kind of right.
Right. That is also a right. Suppose
Right, but where?
there are certain conditions which the Act provides. For, suppose for voting, that 18 years is you have to become major. But to contest, there are certain other criteria, like qualification is also a criteria. Age 25 years is a criteria.
Is it a
So, there
fundamental?
should not be any criminal antecedents.
Is it a fundamental right to vote?
Right to vote, I think it's a fundamental, but right to contest may not be.
May not
It
be.
is not. Because if I have a criminal background, I am accused or I am convicted in a criminal case, I do not have the right to contest.
Because nobody has addressed, that is why.
Because they will have no.
I actually wanted to know.
Absolutely
Hey,
correct.
constitution.
They will not argue because that will not go in their favor. From the argument's sake, not the verdict's point of view. And they are not deprived in any manner. They, in either constituency, will have only single vote. So, may I continue with that?
Yes, yes, please.
In pursuance of the cabinet decision held on 19/6/2004, the governor of Assam is pleased to notify the SOP to be followed for delimitation of Gaon Panchayat, Anchalik Panchayat, and Jilla Parishad in Assam. SOP for delimitation of Gaon Panchayat, etc. Introduction: the SOP delineates the material steps and strategies to be employed for the seamless execution of the procedure of delimitation of Gaon Panchayat, Anchalik Panchayat, and Jilla Parishad in Assam. Objective: the primary objective of this SOP is to ensure a systematic and efficient process of delimitation to be followed by the District Delimitation Commission. The definition of District Delimitation Commission: the District Delimitation Commission, constituted as per Section 3 of the Assam Panchayat Act 1994, consists of the following members. One is Chairman is the District Commissioner, CEO Jilla Parishad is Member Secretary, and election officer, etc. are members. Pausing here for a moment, Lordship. Now, one kind of argument, I'm dealing with the arguments also, that while District Delimitation Commission were constituted in each of the districts, there is no name. That is one of the arguments, what we have noted, Lordship. That the Deputy Commissioner's name has to be given. The CEO Jilla Parishad's name has to be given as Member Secretary. And election officer's name is also have to be given. That is not required in my humble submission. That is not mandate of the Act as well as the normal administrative process. A Deputy Commissioner is the chairman. Suppose the Deputy Commissioner retires on 31st of September, 30th of September. The process started when he was there. He retires. So name again has to be reconstituted. Again, we have to change. He is transferred to another district. There will always be a district commissioner in that district. X, Y, Z, anybody can hold that post. Whoever is at the post, these are ex officio posts. By office, they are part of this delimitation exercise.
So you mean to say by this notification, District Delimitation Commission has been constituted in each of the districts?
Everywhere, there is no doubt. Everybody has participated. In all the petitions, they have annexed their representations before whom they have submitted. It is always before the District Delimitation Commission. And Delimitation Commission has applied their mind, allowed them to have public hearing. In person, they have appeared, not only the individuals, the organizations, etc. of that whole area. All their opinions, all their suggestions, all their arguments were heard, and the proper order was passed after due diligence and after proper application of mind. So, if now at this stage, too late in the day, that they are urging that this district commissioner name should be there. Let us see their prayer, Lordship, for a moment. What is their prayer in the petition? I have made a chart index, Lordship, what exactly is their grievance in each case. Now, Lordship will kindly come to page 28. I'm taking one as an example. more or less it is the same way all the petitions are structured. Here their prayer is A, certiorari shall not be issued to set aside was the final delimitation list of Gaon Panchayat constituencies under Sonai Assembly constituency published by the respondent number 3 on 15/10/2024. The next mandamus shall not be issued directing the respondents to forthwith cancel, recall, resign, or otherwise forbear from giving effect to the impugned final delimitation list of Gaon Panchayat constituencies under Sonai Assembly constituency. 3. Mandamus shall not be issued directing the respondent authorities not to proceed with the election of Gaon Panchayat under Sonai till the final delimitation list of Sonai Gaon Panchayat under the Sonai Assembly published on 40 is modified, altered, rectified, keeping existence of 24 number of Gaon Panchayats under Sonai Assembly constituency. So this is their prayer. And what is their grievance? The grievance is that earlier there were 24 number of GPs under Sonai LSC. It has been reduced to 18. So there is a decrease of 8. Our SOP says in the district the same number of Gaon Panchayats will be there. While making 8 or while making 18 or 24, has anybody's personal or fundamental right has been infringed upon? That is the case. Whether it is the LSC has 24 number of Gaon Panchayats or 18 number of Gaon Panchayats, does that deprive the writ petitioners from franchising their rights of voting? In my humble submission, no. So there may be no ground for any interference in this. Not a single prayer is there that the delimitation commission should be set aside, or it is not in terms of the SOP or under the statute. The statute says, let us go to section 3 of the Assam Panchayat Act 1994.
There is just some confusion, my word. Section 3A. 3A.
3 capital A.
Ah, yes. The government shall constitute. Okay, there is no
Shall
problem.
constitute in every district,
In every district.
line to decide the size of the Gaon
That part,
Panchayat.
that part. To decide the size of Gaon
Gaon
Panchayat.
Panchayat,
Anchalik Panchayat and Jila Panchayat.
the district delimitation commission shall consist of the following
My
members.
query is on that.
Yes.
Whether this district delimitation commission by this SOP is constituted to decide the size of Gaon Panchayat or Jila Parishad or Anchalik Panchayat. There is a catch to decide whether that role has, that power has been entrusted. But because of the SOP, my query.
Lordship.
Nothing has come from.
Yes. Let us go to the SOP.
Yes.
How the things progress. Let
Yes.
us go together.
Yes, yes.
So now,
Because my
yes, I have registered Lordship's query. So that answer will be here itself.
yes. So that is why whether because the notification everywhere challenge is 15/10/2024. And that is by state government.
Yes.
That is why. Then subsequent is by chief executive officer.
Lordship.
To you go by top-down approach.
Lordship.
The first one is 15/10/2024.
Lordship.
That is by state government in the Panchayat and Rural Development Department. And next down is, I think, chief executive officer.
Yes.
Then down is perhaps, I don't know.
I'll address all this.
Right. Just I'm pointing so that you can
Absolutely,
address
Lordship.
whether it is really a delimitation exercise or a readjustment process.
Delimitation exercise, same was done in Sincere Municipal Corporation. We have done the same exercise. The deputy commissioner and 2 other persons did that exercise. And after hearing all the objections and after giving their opinion as recommendation, it was sent to the DISPUR. Their department is Dohua. Department of Urban Housing. Earlier that was
Okay.
the GDD department identical. In Dohua, they have applied their mind and
on the basis of the recommendations of the district in that it was the wards. I think I argued that case before Lordship. That was identical challenge was there and it was upheld that government have done it as per the procedure. This delimitation commission does not have the authority to give the publication. The publication of the authority is given to somebody else. That is at the level of government. I'll place it, Lordship. But as it was not argued, I'm not really finding out that, but I'm giving it.
It looks, but because
And it is very logical. Lordship.
everything has fallen from that Election Commission of India notification.
Yeah, that is the number one criteria
Yes,
of delimitation.
that is.
Now the Lordship, what Lordship precisely wanted, what is the role entrusted to District Delimitation Commission? That is basically the query.
Yes.
What is their terms of reference?
Terms of reference, because
Understand, Lordship. So I'm going to take the. In our rules and statute, everything is there. So serial number 4.
yes,
Delimitation of Gaon Panchayat. Criteria for the delimitation. The ECI notification dated 11th August 2023 is to be diligently referred to for source of Gaon Panchayat and village falling in an LAC. So LAC is the Legislative Assembly constituency. Here, the whole exercise, why this exercise has to be undertaken, Lords? We have to understand that. After the Lok Sabha and the assembly constituencies are delimited, that means changed, modified. There is a unsettlement of the Anchalik Panchayats, Jilla Parishad and Gaon Panchayats. So it is a corollary exercise. It is a consequence of that exercise. Therefore, the first criteria is that the ECI's notification of 11th August, which is put to challenge before the Honorable Supreme Court, has to be diligently referred to for source of Gaon Panchayat villages falling in an LSC. Otherwise, there was no occasion for the government to go for delimitation of the Jilla Parishad, Anchalik Panchayat and Gaon Panchayats. As because in the next strata of our democracy, that is the assembly, and after that it is the Lok Sabha, general. There is a change at the top in the 2 higher levels. So consequences of that is that there will be change in the constituencies also of the Anchalik Panchayats, Jilla Parishad and the Gaon Panchayat.
yes, yesterday just so that,
Lots of.
yesterday I put the query that this should come from bottom up or top down. My tentative view is it should come top down.
Top down.
Not bottom up. It will be an impossible task to
Very difficult.
fix everything. Parliamentary constituency, then assembly constituency, then district, Jilla Parishad, Anchalik Panchayat, then
Gaon Panchayat.
it will percolate down to Gaon Panchayat.
Absolutely.
That is what I say. I don't know, tentative view. Otherwise, this constitutional principle in 243C will not be possible to implement.
Take the example of a state.
Yes,
A state is first constituted.
yes,
Then we'll decide how many districts should be there.
yes,
And within the district, how many subdivisions
yes,
and how many blocks. You come out that way, Lordship. Suppose we are starting from the reverse way, then
yes.
we have to, at the end, we have to either increase or decrease the size of the state, which is not possible.
Yes.
Exactly, Lordship. That is. So
Okay, let us.
here the ECI's notification, and very interestingly, none of the writ petitioners have annexed this notification. I'll place that also. In that, Lordship will kindly see. Very interesting. Whatever has fallen from Lordship, it has a connector.
I have been putting questions. Mr. Dubey must be aware, and I have been asking Mr. Dubey to produce the, ultimately,
He is doing he is burning lot of midnight oil. Last night also.
okay,
He gave me some very interesting facts, which I should not disclose now.
yes,
This is the Election Commission's notification 11th August. Lordship will see. pursuance of Section 8A of the Representation of Peoples Act 1950, read with Presidential Order dated 28 February 2020, the following orders made by the Election Commission of Assam under Section 8A of the RP Act 1950, read with Presidential Order dated 28 February in respect of the delimitation of parliamentary and assembly constituencies in the state of Assam, he is hereby published. I'm skipping all these things. Now coming to next page. Now therefore in pursuance of the so and so to amend Schedule 1 and 2 and Schedule 5 with regard to the state of Assam to the delimitation of parliamentary and assembly constituencies, the Election Commission hereby determines as follows: 126 constituencies into which the state of Assam shall be divided for the purpose of election of Legislative Assembly of the state, and the extent of such constituencies shall be shown in Table A. The Table A is below. So a lot of new areas were inserted, some areas were excluded also. Now coming to the last page. All 126 demarcations are there regarding all the constituencies as well as the LSCs. Table B is the parliamentary. That is the previous page before. Yeah. And Lordship will kindly take the note here. Why the SOP has put this as serial number 1. Note. Have Lordship got it? The last page. Any reference in Table A to a district development block, panchayat is also there. That is what I am trying to emphasize. Or village council development committee, village ward, and other territorial limits shall be taken to mean the area comprised within the district development block, panchayat, and VDC, village, municipality, ward of other territory as on 1st day of January 2023, except the Guwahati Municipal Corporation, wherein the name and extent of ward has to be taken as existed in 2001 census. So we have to consider various factors here, including the 2001 census report. Our delimitation exercise 2 years ago was done on 2001 census, not on 2011, and neither on 2021.
Cannot be by the constitution itself, it is 226. 2026.
Yes.
By the constitution itself.
Absolutely.
Only 2001 up to 2026.
Yes. After 2026, we may take 11 or 20.
Or
we do not
things
know.
may be different.
So all these arguments of Section 5.1, etc., will fall flat in terms of this notification, because nothing survives. There cannot be any change. That is why SOP itself says the number 2. I'm coming to that now.
Yes.
Two, the number of Gaon Panchayats in the district shall remain same as that of the current number of Gaon Panchayats in the district after LAC delimitation. So there is no tinkering with the size and number of the district as well as the vis-a-vis the number of Gaon Panchayats. One Gaon Panchayat shall belong to one LAC. That is, no Gaon Panchayat jurisdiction shall be shared with more than one LAC. So this is the reason why the delimitation for Gaon Panchayat was necessary. 4. If a Gaon Panchayat after LAC delimitation is not shared among more than one LAC, then preferably the Gaon Panchayat boundary will be retained. If a Gaon Panchayat after LAC delimitation is shared among more than one LAC, then the villages under respective LAC either may be grouped to form a new GP or may accommodate the nearby existing GP provided criteria 4 Roman 2 is not violated. If a new Gaon Panchayat is to be formed without violating the criteria of Roman 4.2, the population, natural boundary and category of the district shall be considered as per Section 5.1 of the Assam Panchayat Act 1994 as amended.
Whether such an event has occurred?
That situation never arose.
Because yesterday it was argued.
Yes, it was argued. Earlier occasion, it was also argued that there should be a notification regarding the status of that village, a district, in 3 categories. That is not required because we have taken a conscious decision at the cabinet level that this is not required because we are not going to touch the district boundary, number 1, and either to increase or decrease the number of GPs in a district. So that is why it is not necessary. That 5.1 is whether it is mandatory or directory. I'll come. The main first part uses the word may, the second part uses the word shall. All these things will argue, Lordship. So my humble submission is that that's as because 4.2 says that number of Gaon Panchayats in the district shall remain same as that of the current number of Gaon Panchayat in the district. Lordship will kindly note that in the district after LSC delimitation. So that situation, had it been a regular delimitation exercise, suppose there was no LSC or parliamentary delimitation exercise. Otherwise, government wants to do it. In that situation, that notification may have some importance.
number of district at the time of election commission delimitation exercise and panchayat are same.
Absolutely same.
Because Tamil Nadu case will come.
Yes. Here also, we increase the number of districts and again you reduce it for the delimitation. Lordship, remember that we had Ojai, we had Vishwanath, Tamulpur and few newly created. But again,
But
we have
before ECI.
Yes, before that, before ECI, it was merged again.
So
Everything
ECI
was
notification and position as on today is same.
Same. It is same. So there is no increase or decrease in the number of GPs in the district. Therefore, 5.1 has become redundant more or less. As per LSC, delimitation, if a Gaon Panchayat is divided between two districts, then the Gaon Panchayat will be considered in the district having the Gaon Panchayat headquarter. I don't think any such situation has arisen in the present
As per
delimitation exercise.
divided in two districts. Okay.
If the Gaon Panchayat falls under both Kamrup Rural and Kamrup Metro, then it will go to that district where the Gaon Panchayat head office is situated. After delimitation of the Gaon Panchayat, the delimitation of Gaon Panchayat constituencies, that is 10 number of wards within the Gaon Panchayat shall be done as per section 6.2 of the Assam Panchayat Act 1994. These are not argued, so not much relevance. Number 10, the categorization of district based on population density or any other relevant factors shall be followed as per section 5.1 of the Assam Panchayat Act. So this is also put to a condition. So it is there is no change in the number of panchayats, etc., the population will remain same in the district. So that status situation is not called for.
That 9 and 10, just a moment. After delimitation of the Gaon Panchayats, delimitation of Gaon Panchayat constituencies 10 in number within the Gaon Panchayat shall be done
as per section 6.2. 6.2 says constitution of Gaon Panchayat election president and vice president. The Gaon Panchayat shall consider 10 members to be directly elected by the number of voters. So number of persons who will be elected, all these things, Lord.
6.2.
6.2. For convenience of election, the prescribed authorities shall, in accordance with such rules as may be prescribed in this behalf by the government, divide the area of the Gaon Panchayat into 10 territorial constituencies and allot 1 seat to each constituency. So that is within that Gaon Panchayat. That is further division of the Gaon Panchayat.
Okay.
That means in one Gaon Panchayat, there will be 10 ward commissioner. So what will be the area? That will, another notification under 6.2 has to be issued.
Because this thing or as a whole brother, some submissions were made in the context of 243C.
In 243C, let us
article.
as far as practicable, what is
Yes, as far as practicable. Always.
composition of panchayat.
Yes, yes.
243C. Subject to the provisions of this part, the legislature of a state may, by law, make provisions with respect to the composition of panchayat.
That is Assam Panchayat.
Assam Panchayat Act 1994.
Proviso.
provided that the ratio between the population of the territorial area of a panchayat at any level and the number of seats in such panchayat to be filled by election shall, as far as practicable, be the same throughout the state.
And
And all
Clause
the
2.
seats in the panchayat shall be filled by persons chosen by direct election from territorial constituency in the panchayat area. And for this purpose, each panchayat shall be divided into territorial
This part.
constituencies. Shall be divided into territorial constituencies in such manner that the ratio between the population of each constituency and the number of seats allotted to it shall, as far as practicable, be the same throughout the panchayat area.
some submissions were made.
What they are saying is that now let us, for the time being, what are the grievances? Because we have to deal the facts they have risen or highlighted in their grievance. I'll give the chart. What exactly are their grievances and what are the issues they have raised before the Delimitation Commission at the time of calling of objections and hearing of the objections. Here, initially, there are 10 unit petitions.
Yes.
So we have compiled this. Number 1, WPC 6413, Hailakandi, State of Assam versus Samsudin. That IAs are filed by state. There was an interim order, we wanted vacation. So representation dated 28 September 2000. Their grievance is, Lordship, that number of Gaon Panchayats, Anshalik Panchayats have been formed in 121 LSC is lesser than 122 LSC despite slate population in 121 LSC. So this is the total number of Gaon Panchayats they are agreed that the nearby constituency has one more than us. This is number 1. Number 2, the grievance is after delimitation of Sonai LSC, total number of Gaon Panchayats has been decreased to 18 from 24. So 6 Gaon Panchayats have been reduced in a particular LSC. The size of the LSC has changed, Lordship. We have to admit and accept that fact. That is precisely the reason where there is a addition or subtraction of the number of GPs, because the size somewhere, and there are various factors of changes in the LSCs. One is the population pattern, one is the geographical terrain, etc. 3. The third case, state of Abdul Ahad Laskar, delimitation is done in violation of SOP, not considering the density of population. They have to come up with exact facts. What is the density, what it should be. Just saying vaguely regarding this will not be sufficient, because the constitution as well as our act also says, as far as practicable, that word has lot of importance.
Yes.
It cannot be having mathematical precision. Number of development blocks are not sufficient considering the number of population. This is the second grievance. So these grievances are not there. Suggestions was made for change of the name of some Gaon Panchayats. So they wanted better names. They are not happy with the name. So that is their grievance. Very flimsy, Lordship. I am reading further also. Again, the next writ petition, Nilima Begum, against Sonai LSC, Gaon Panchayat has been decreased to 18 from 24. Then the next writ petition, Dilwar Hussain Borbhuya, more than 3 development blocks may be created in Algapur Katlichara LSC. Dokhin Josnabar Part 1 and Part 2 may be added with Niomatabad and Serilipur village to create separate GP. So they want the 3 number of development blocks. Number 2, they want a separate Gaon Panchayat. What personal right has been agreed? Then next petition, Habibur Rahman, Sidhaguri and Patekibari village falling under Babhakati Gaon Panchayats are 7 kilometers away from Puronabiri Gaon Panchayat. Therefore, the same may be kept as Pavokati Gaon Panchayat. So one is that name or maybe the inclusion in another GP and the distance 7 kilometers. Then next writ petition Abdul Motleb. Brahmashan LBL Part 1 Revenue Village is attached to Hajim Dolgram Gaon Panchayat, which is 8 to 10 kilometers away from the said village. As such, same should be attached to Ranibari Gaon Panchayat, which is nearer. So he wants a nearer Gaon Panchayat than the distance one. Next page, village Dangshuli Khul, ward number 7 of Lajambur Gaon Panchayat is shifted to Mahakal Gaon Panchayat GP, having no geographical contiguity. So it has to be connected, that according to them. Then the 9th writ petition, village Puthimari Chapori ward number 4 of Puthimari is included in Oritri Khaiti Gaon Panchayat, which is situated more than 20 kilometers away. Our note is that writ petitioner is not a signatory to the said representation. So he did not raise grievance before the Delimitation Commission. Then the last case, Ali Ahmed Loskar. The petitioner objected for inclusion of village Visingasa Part 2 in 47 Bawarhat Gaon Panchayat and proposed for shifting of Visinga Part 2 to 43 Rangoti GPS Rangoti GP. So these are the grievances they have raised before the Delimitation Commission at the time of calling of objections, claiming objections, and hearing. So whether these can be any ground to interfere with the delimitation exercise in a writ proceedings. These are the grievances. We cannot go beyond. They can make lot of arguments now. But whatever objections they had before when the process was going on and when there was a specific call to a notification, that if they have any grievance, any objections, any suggestions, they have to come. 3 days were given to submit their complaints. That's schedule I have already placed, Lordship. And there was specific days of personal hearing also.
How the principle of 243C is maintained?
Here, we have to go to every individual case, if that is a factual determination.
No,
because if that Lordship wants to know, then we have to
it has
all the
it has been argued as far as practical that part is there.
Yes.
But whether that while exercising undertaking the exercise and completing, whether that principle is kept in mind or not in some manner or other, that is what as far as practical gives the leeway to the authorities.
Lordship.
That I know. Just the principle is kept in mind or not.
These are basically cosmetic changes. Just to align with the LSC as well as the parliamentary constituency. These are all cosmetic changes. That is why hardly in Assam there are 2100 Gaon Panchayats. I have the figures, we have placed it in one of the IS. We have 2100 plus. How many have come? In the first round, 9. Now I think it will be not more than 30. So everybody is happy. We have to take into consideration. That's why one of my submissions is if they do not want election, let their election be closed. If that is their case, but they cannot represent the whole constituency also of their Gaon Panchayat. When that NGO says all the people are with them, except some are which are excluded by them, that's stated in paragraph 1. It is
whether in any of the writ petitions, this it has been verbally submitted. 243C is indicated. We did.
No basic, not a single. That is what that last night's hard work was on that point. We want that because we have also heard the query from Honorable Court also. That where is the foundation of the figure? That was the query I have heard. That is why he waited till 2 o'clock midnight, finding out through all the writ petition what is the case. So he read most of the writ petition yesterday to find out if there is something like that. By so?
243C, no.
In all statement that there is a violation of 243C.
But with the context of identified data, is it mentioned?
Absolutely.
No.
Quantifiable data is required.
Because it is not possible for me to go through.
No. we are making it with full
Ah.
responsibility. That's why before all this question, I said that he had done lot of hard work. That was one of the reasons why he had to go through all the.
Because everybody is making submission on
Yes,
243C.
that is why.
And
Now,
for me, it is difficult to go through the identified data and compare or something.
exactly, Lord. Now,
So I take it as a statement that no factual foundation has been laid down. Because I'll not go through. Yes, petitioner side. Petitioner side, any factual foundation, 243C,
In details,
where?
in 5771, in 48,
5771.
in 48,
Which one?
Uh,
5771 we'll see.
and in the 48, my lord.
577
48 lordship will not take.
may not. Let us see the other one.
5771, my lord.
5 item number. Clause 5 and clause 6 of the SOP appears to be conformity substantially with the ECI
Lordship.
Panchayat Act.
Yes, that is why that exercise was not required.
And Anchalik Panchayat is co-terminus with development block.
Lordship.
So nothing has been, only clause 4.
Only
They have
clause
been
4,
hesitating
down
and
Panchayat it is required.
yes.
So that is why Anchalik Panchayat and Jilla Parishad, it was not required.
Yes, where have you said factual? Any mention of
My lord,
243C?
my lord, otherwise details, first pages of all the words I have annexed.
No.
Where the
I am
details?
asked.
Yes, madam.
Mr. Talukdar, there is a law of pleadings also. So where have you mentioned specifically 243C article?
My lord, kindly take the
To
affidavit.
take a law point,
Yes.
factual foundation is to be laid,
Yes,
right? So where is the pleading? That is what I am asking specifically to you. Please answer specifically to my query.
my lord, I have filed.
Ultimately, the burden
Yes,
lies on the
yes,
court.
yes, yes.
This don't waver this way, that way.
Yes, my lord.
You have this petition running into 25 pages or 20 so and so pages, 27 pages. Please tell me where you have raised the issue of 243C with some kind of, some semblance of factual foundation.
Yeah, yes, my lord. I have filed
Please.
an additional affidavit in this particular point, my lord.
Additional affidavit. Okay, additional affidavit.
There is a single amendment of only mention article 243, no 43C, single.
243 is definition.
Broader,
No, 243 is definitions only.
there is no specific mention of 243C in the rectification.
In the additional affidavit?
My lord, two affidavits filed, my lord. One is regarding the maintainability, my lord, regarding their voters.
No,
and another,
I am, Mr. Why we are going into maintainability 5771, I am looking
yes,
at.
yes, my lord. And another affidavit, my lord, same affidavit filed in 48.
This is what?
My lord,
This item 48. No, other one?
my lord, the exactly same affidavit is filed in 48 also, my lord. So if not it is available there, my lord, 48 may be taken. This additional separate part is filed, my lord. In the 48, my lord, separate additional is filed, exactly the same, my lord.
In the whole body of writ petition, 243 C is not mentioned.
243 is mentioned, but my lord,
Mentioned where? Where mentioned?
my lord, at paragraph, my lord, paragraph 2, my lord. C is not mentioned, only 243, my lord.
243 is one
Yes,
thing, 243 C is
yes,
another
yes,
thing.
And my lord, on this particular
Don't say
aspect,
it typing mistake. Now, where in the additional affidavit you have mentioned?
My lord, if it is not available, this my lord, kindly, in 48 and 5711, that was on the same affidavit file, my lord, exactly same, my lord. So, my lord, additional affidavit filed in 48
No, I am looking at this one, 5771. Please tell me.
Now, asking for it.
243C. Because submissions were made by Mr. H.R. Sodri and Mr. A.C. Borbora on 243C. Mr. P.K. Roy Churi's argument, it is not there. It is not there. 6 issues not there. So,
My lord, as I have filed the exactly same additional affidavit in 5771 and 48.
I am asking you on 5771.
My lord, yes, my lord.
Where is that additional?
243, if it is not in the record, my lord, I
look at additional affidavit in opposition. No. Your additional affidavit, okay, it is there. Tell me.
My lord, 2 affidavit filed. 2 additional affidavit. One is very small and one is big, my lord.
Both are here. Tell me.
Then, my lord.
Tell me. Sometimes I feel I was better on the other side.
Always not, anytime.
My lord, I have annexed the extract.
Pleadings means statement.
My lord, statement.
Mr. Taluda, please. To raise a law point, some kind of factual foundation is to be laid. I think Bharat Singh. Huh? Bharat Singh.
From the other side also counter that.
Yes, yes.
My lord, 240C is not, my lord, stated in paragraphs.
Huh?
Not stated in paragraphs.
Not.
Data is given. Supporting data is given. But only in paragraph 2 it is mentioned.
Okay. Yes. Yes. Otherwise, this issue again is different. No? I have to deal with it.
Then lordship will kindly come to delimitation, then 7.
Clause 4.
The clause 4.
Over.
Clause 4 is over.
Over.
Up to
Okay.
date. 5 is delimitation of Anshalik Panchayat. 6 is delimitation of Jilla. Now 7. A LSC level task force is proposed for the delimitation of Gaon Panchayat, Anshalik Panchayat, Jilla Parishad and block reorganization. The LSC wise task force will execute the delimitation and reorganization process at the LSC level. The district delimitation committee will form the LSC level task force from the respective LSC of the district. The composition of the LSC level task force is as follows. So these are the work designated to them and the members. The LSC task force will report to the CEO Jilla Parishad, who is the member secretary of the district delimitation commission. Role of the task force: the LSC task force will report to the CEO Jilla Parishad, member secretary of the district delimitation commission. The task force will collect the LSC wise list of villages and respective Gaon Panchayats name from the district delimitation commission as notified by the ECI in LSC delimitation. Once the LSC wise villages list is collected, the Gaon Panchayat is to be assigned against each village. Public consultation, publication of the draft delimitation notification, publish the draft delimitation notification to invite objection and suggestions from the public and civil society, latest by 6 September 2024. Public hearing, organize public hearing at district and block level to gather feedback and dispose objection and suggestions latest by September 7, 2024 to 16. This has, to the addendum, there is a change of the dates. Finalization of the delimitation notification, the final delimitation process of Gaon Panchayat, Anshalik Panchayat, Jilla Parishad, and notification for the same by District Delimitation Commission is to be completed by 17th September 2024.
So I am asking
Yes.
whether it is a delimitation in the proper sense or it is because the thing is set already. It is a readjustment. Well, as an advocate general, I ask.
Lord.
In the proper sense, it is delimitation or it is basically the thing is set.
All
Thing is set.
two levels it is set.
Ah.
So that is why this task force, they are collecting all the names.
Village name from the
Yes.
ECI. ECI. See the
Yes,
role of
ECI.
task force.
ECI.
Once LAC
The
was
source is ECI.
yes.
ECI in the LAC delimitation.
The Gaon Panchayat is to be assigned against each village.
Yes.
Putting
Yes. Yes.
like
Left,
that
right.
in a post office, every bunch comes and there are boxes.
Area
Violent
wise,
number, violent number, so and so, you put it.
pin number wise.
Yes, pin number, you put it. Is it
It is
delimitation in
the
a
task has become very easy now.
easy?
It is very easy.
Yes. Because I have seen one Supreme Court judge, it is readjustment.
Yes, Lord.
Some 2-3 judgments I have seen, it is readjustment, not delimitation. That is why I am asking.
In other words, there is a very fine line of difference when it is a delimitation or readjustment. Readjustment also will become delimitation because that will also delimit the constituency size. Section 3, that it has to be group of composition of some villages.
Okay.
So the delimitation commission is to be completed so and so, and that is the first. Then there are subsequent notifications also. Regarding the
Sorry, my lord, I have got it, my lord. Sorry, my lord. In paragraph 22 and paragraph 23, my lord. 243, article 243 to 243 O, my lord. Mentioned it twice, and in the cost title also. Sorry.
So my response straightway will be that is reference to the constitutional provision. To invoke that provision, lordship, you must have some factual foundation. That factual foundation is not.
Can I just roll up the task force just to understand once again in the
Task
SOP?
force, because delimitation.
Because that LSC task force will report to the CEO.
CEO.
Okay, done.
Who is a part of the District Delimitation Commission.
Then task force will
Will
collect the
LSC wise name of villages.
LSU's list of villages and respective Gaon Panchayat's name from the District Delimitation Commission as notified by the ECI in the LSC delimitation. Once LSU's village list is collected, the Gaon Panchayat is to be assigned. This part is what? The Gaon
That
Panchayat?
means every village will come under some Gaon Panchayat. It is on the reverse. Language is not very properly framed. The Gaon Panchayat is to be assigned against each village. Rather, we should say that each village have to be assigned against one of the Gaon Panchayat. It should have been reversed, but meaning is same. It is not a very happily drafted line.
Okay.
So no village is left out in the process. Suppose a village is left out from becoming a part of any of the Gaon Panchayats, their legal right would have been violated. They will be deprived of being a part of the Panchayat institution, or they are part in the election process also. So that is not the case in any other institution. Then public consultation is there and finalization of this area. And this was published in the Government Gazette notification, page 36, serial number 11. Because one of the submission of my learned friend in the earlier round that there was no notification.
No, I'm looking at Gazette only.
Each
So I
time
have,
we produced it, there was a doubt casted by them that this may not be the correct, as if we have prepared the frame, manufactured a notification.
once
at
it
home.
is found available, I am looking at the Gazette only.
On these lordship, serious arguments were made by very senior councils in the earlier round. And when we have produced it, thereafter also they are disbelieving. That is the status. That is why I am saying, no, who can contest? He has to be a citizen of this country.
Yes.
Then we must believe in our system. When a gazette notification has been issued and placed before the Honorable High Court by a responsible law officer of the state, it has to be believed. If you don't believe in the institution, don't come with a 226 writ petition also. Tomorrow lordship may pass, which may go against them also. Then they will cast aspersion. First, we have to believe in the system. Now, what were there represented? Annexer D, page 44. I am trying to place their case because they are arguing on all other things except their own pleaded case. Most of the councils I have found. Annexer D, page 44, the representation they have submitted before the State Election Commission 21/9/2024, date lordship will find at
Which
page
petition?
46.
Which is 5346.
Yes, lordship. 5346.
It's a long one.
Long one, but I'll read the subject only, lordship.
Yes.
Complaint against arbitrary and illegal action on the part of the District Delimitation Commission of Kachar District in reducing the total number of Gaon Panchayat constituencies from existing 24 to 18 numbers in violation of SOP as well as Section 5 of the Assam Panchayat Act. This is their grievance. Then lordship will kindly come to page 47. So it was not actually properly addressed. It should be addressed to the district commissioner and this district delimitation commission. Here
Chairman.
also the same subject from 24 to 18. Then another at page 50. Here also 24 to 18. Then another complaint at page 53. The existing Hathikal, lordship will see the number, serial number 1 to 3 complaints. Representation from existing Hathikal Gaon Panchayat for review of the draft GP limitation list. The existing Hathikal Gaon Panchayat is comprised of 5 number of revenue villages, namely Bidrohi Par, Bharuta Kandi Part 1, Bharuta Kandi Part 2, Fundori Part 1, Fundori Part 2, with about more than 7,500 electors. The draft publication of delimitation adds 2 new revenue villages to the existing Hathikal GP, namely so-and-so, with 2,400 electors and Kanchan 26 electors, besides changing the name of the prestigious Hathikal Gaon Panchayat to Bhorakandi Gaon Panchayat. That the geographical area of the newly created Bhorakandi would be very large, with about 12,500 electors and 25,000 population, which will be very challenging in providing social justice to everyone through Panchayati Raj institution. In view of above, we undersigned do hereby request your honor kindly to accommodate so-and-so village in which so-and-so is there one changes of the composition in that last paragraph. My submission is that multiple causes of actions are inserted in the same petition. Everybody has different grievance. How can this honorable court pass an order here? Even lordship wants to give a favorable order to the petition. That is number 1. Number 2, they want different types of composition of the Gaon Panchayats here. Their case is that paragraph 3, that with the large number of 12,500 electors and 25,000 population, which would be very challenging in providing social justice to everyone through Panchayati Raj institution. They should know, we have part of that record, how the Finance Commission fund is coming and distributed among various Gaon Panchayats and Anchalik Panchayats and Jilla Panchayats. One Gaon Panchayat may get lesser amount of fund, the other will get little bit more, depending upon the number of beneficiaries. Geographical area is another area consideration. Why some areas there are more people, some areas less people. There may be hilly and hostile terrains. Their population density is less. In some areas where it is more of a sort of a mofussil town. Also, they are falling under Panchayat. It may not be a urban area. The concentration of population is much more. Various factors are there, Lordship. Those things cannot be decided in this honorable court. For that, a ground level recce has to be done, which this Delimitation Commission, with the help of the task force, they are doing. Very clearly, it is shown that there is a marginal increase in the number of persons inserted in a particular Gaon Panchayat. And they want, in the last paragraph, they said, may I read it? In view of above, we understand, do hereby request your honor kindly to accommodate Kachudharam Part 4 Revenue Village with 2400 elector to the existing Hatikhal GP and detach Notun Kanchanpur from the draft list, accommodating it to any other nearby Gaon Panchayat, keeping total number of electors in Hatikhal at 10,000 only. Further, you are also requested to restore the existing prestigious name of Hatikhal GP in lieu for Bauri Kandi Gaon Panchayat in the final publication of the delimitation list. What Lordship was saying, picking up one area, they want to do it themselves. So it is not as per their request, it is happening, so they are coming before this honorable. If we do the reverse, some other group will get aggrieved. It will be a never-ending exercise.
Well, otherwise, state is enjoined to keep this principle into perspective, that principle. That is what only that perspective is taken or not. Because they may say, oh, I will not go into that. They are saying somewhere Gaon Panchayat 3,000, somewhere it is 6,000. That I will not go into it. But question is, perspective is, what is
perspective, that is the
boundary, okay, geographical terrain, hilly area, lesser population, these factors are to be kept, and somewhere it will be more, somewhere it will be less. But the principle is in the background or not?
Definitely, we cannot,
because I have
keep
seen
aside the constitutional mandate and do
in
some
the
constitutional work.
affidavit is not. Affidavit is your affidavit.
When the deputy commissioner is doing his constitutional duty, definitely Lordship, nobody. That is why not a single specific case, which is specific allegation.
Okay.
Really, we cannot. And on top of that, my submission is that there are cosmetic changes. So it was there since long time back, when the Gaon Panchayats and the Panchayat Raj institutions came into
Then
existence.
this page 60.
Page 60, yes, Lordship. Binan Kandi, number of name of villages.
No,
So this is a notification.
this exercise, power.
In exercise of the power conferred under subsection 2 of section 5 of the Assam Panchayat Act, and in pursuance of the cabinet decision taken in its meeting held on 8/10/20, the governor was pleased to notify the following Gaon Panchayats along with their corresponding villages on Kachar. So this was issued by the department.
Let us take Panchayat Act.
Yes. The recommendation has to be made by the District Delimitation Commission. That I have just found in the rules. The recommendation part is their job. The ground level verification, hearing of objections, inviting objections, giving their opinion, everything they have to do and send it to the government.
Two things I want to know from
Rule 6.
Section 5. Why I am asking, there is just section 5.
Lots.
1. 5.1.
5.1 Lordship.
The state government may by notification.
Yes,
This is one.
yes.
They're arguing. Subsection 2. After consultation with the Gaon Panchayat, comma, if it has already been established, comma, the government may, comma, by similar notification at any time. That is why I am asking, by similar notification means there are two modes of doing it. Looks like. And you have not exercised that option, categorization. It looks like. Subsection 1, that categorization of district is not done. You will address on that point, perhaps.
Yes, I'll address.
Why this by similar notification? That is another mode of doing it.
We could have done.
No, because this notification, this
5.2.
challenge is made
Under 5.2.
5.2, and they are challenging this. And 5.2 does not say categorization of district. That is why I am asking it. By a similar notification means,
I got it, Lordship.
have you got it?
Yes, yes.
And state government is making this notification under subsection 2 of section 5.
Lordship.
And whether this is another mode of doing it, because
This is a new vertical of doing it.
Yes. No, that is why I'm asking right from very beginning that it is.
Lordship is absolutely correct, because if we see the notification also, it is 5.2.
And government means government in the Panchayat and Rural Development Department.
Yes.
That is why I'm
There
asking.
is no doubt about that.
This exercise of power under subsection 2 is another power or the same power by similar notification.
And that is why, and after consultation.
Yes, if it
The
is.
consultation is done.
That is why I'm asking from the very beginning.
Consultation is done with whom? The Delimitation Commission consulted with all the stakeholders.
So that may be via, that is, he is the via media, district delimitation commission could be the via media.
No, it is a statutory body.
No. This
Three
consultation,
Yes.
state government may not directly consult, it may consult through the district delimitation commission.
Which has been done.
That is why I am asking these questions to everybody. This why 5.2? Because this notification for every district, 5-6 district, they have challenged this apart from SOP. And this is under subsection 2 of section 5. And this power is different. See, read further.
Yes, they're adding or subtracting any area.
That is what I am saying, the example of post office.
Lordship.
That is why I am asking. And if this is done with constitutional principle in mind under 243C, things are different. That is why I have been putting questions. Sorry for putting questions.
That is why Lordship was always better this.
No.
No. This is a very, Lordship, the language is also clear. Language is also clear.
And consultation of Gaon Panchayat may be through district delimitation commission. That is why I am asking you.
That role is prescribed. And their role is that they have to do the consultation part and give recommend. They cannot constitute.
That is why I am asking from time to time, directly or indirectly, because this is sole prerogative of the state government under 5.2. Without district delimitation commission, that is why I have been taking you to decide 3A, district delimitation commission has to decide. They have not decided, it is state government is deciding. So whether it is a power exercise under section 5.2 solely by the state government, that is what I am asking. Am I clear?
Absolutely. And we have to read it.
Include or exclude, they are doing.
Everything is here. Some village can be added, some can.
That is power is there.
Can be excluded.
Unless that is not challenged. This 5.2 notification, where this notification is challenged everywhere. And my query is that if it is solely under section 5.2, then state government has done it.
Lordship, for a moment may also see This part is otherwise very clear.
It is up to
Six.
you.
Yes. Rule 6.
Yes.
Rule 6 says delimitation of the constituencies in a Gaon Panchayat. The district delimitation committee constituted under section
Mrs.
3A of the
Pakia,
Act
that has
shall
that,
recommend
that rule has come later,
in December.
December.
Recommend the boundary of a Gaon Panchayat for declaration of the Gaon Panchayat under sub-rule so and so.
This is new one. After everything is over.
But still in earlier one also.
It is down below. It is down below.
Yes, Lordship.
In the book.
Earlier, it is in the statute, the section. Section itself is also said. Section 3A also.
The district commissioner. See the subsidy previous provision. এখন পড়ি না section rule 5 rule 5 rule 5 rule 5 some constitution rules 5 refers rules you are saying rule 6 right?
I was saying rule 6 but that is new.
No, this one is old. Down below.
Yes.
The district commissioner.
That is a subsequent action, Lordship, regarding the ward.
District commissioner. District commissioner or the subdivision officer, as the case may be, said immediately after declaration of Gaon Panchayat. Gaon Panchayat delimit the number of constituencies as per section 6.2.
That is a subsequent action which has been contemplated.
But already you have done everything
We have done.
by this notification.
Because when suppose the act itself is sufficient, then rules may not be required also.
Yes.
That is the law. Without rules also we can do lot of
This Binakandi,
yes.
Anchalik Panchayat, then you have divided Gaon Panchayat, then villages. 15/10/2024 notification.
Yes.
Page 60.
Page 79 also. Page 79.
Every notification under challenge is
So it
issued.
starts from 60 and page
Yes.
79 Binan Kandi is there.
No, name of the Anchalik Panchayat, name of the Gaon Panchayat,
And
name of the villages.
Absolutely, all are there.
So that is why I have been putting the question. Because section 5.2, clause 1 says specifically that include within or exclude from any village, any local area, anything, so and so. Declare any local area shall cease to be a village. Thereafter, so all these are there.
All are included. 5.2 mentions about villages also.
Village
Areas also.
Micro.
That
is
you
why
can go to the code.
I have been asking that query whether this is an exercise. Because your affidavit is not on that point.
Lord.
I have read only 2 affidavits. In the first 2.
One affidavit little bit elaborate. That is there. But
Yes.
when these type of questions are not raised in the repetition, whether we should respond by giving all. That is another way of rebuttal.
But this is a
Sometimes
law
what
point.
happens, we tell more things and later on the case takes a different turn.
Yes.
So this is the notification of 15th October. And thereafter, on 26th, 28th, no? This self-assessment.
Thereafter, another notification by district bodies. District bodies, whereby these wards have been done. I think.
That is 6-2.
I think 6-2.
6-2.
I think 6-2.
6-2. And thereafter, the final electoral roll was published by the State Election Commission on 28th of December. Some writ petitions are connected with that also, where there is some left, some voters were not, names were not included. We considered before the court, they let them give representation, and that will be rectified. So that exercise is now going on. So now what remains? I have to deal with the overall situation, specifically the arguments made by them. Could I do on some other day, Lordship? If I am allowed to close today. Up to this, basically the factual parts. Now I have to, what were their arguments of the other councils? We have segregated all the points and one by one we'll deal with. Lordship.
When?
After 23rd, it will be convenient, Lordship, if it is not too late for this honor report.
No, not for me. I am ready for tomorrow also.
Tomorrow, Lordship, lot of cases, and today whole morning I was standing in one.
Because
case.
I want to finish it early.
All other cases got adjourned, and most of the cases are listed, is going to be listed tomorrow. So if it could be on 25th or 26th, Lordship.
My lord,
25th or 26th.
we have otherwise no objection, but thing is that if election is declared,
election will be declared. Election will be declared any day thereafter.
Then my lord, then it is your doors before your lordship will be in.
If they do not want to have election in their consider, let them have a specific statement. Will not hold election in their constituency. Election will be declared maybe in the first week of April.
Mr. Taludar, in 9 of the cases, division bench has tied the matter. And in all other cases, the coordinate bench has declined the interim prayer. By the same order, where 9.
My lord,
then what my hands are tied so far as
my lord in 48,
my hands are tied, Mr. Taludar.
My lord, in 48, in the last paragraph of the interim final order, it was reported that interim will be considered. It was recorded that it will be considered.
Where?
In the
division bench?
No, my lord, single bench.
See the division bench order. See the division bench order.
Yes, in these 9 deputies. So if election is declared, my lord, what will be the outcome, my lord?
I don't know.
The first week of April, so my friend is asking for 24th or 25th of March.
Suppose I am sure it is going to be declared after completion of all the examination. It can be on 29th also, but it can be on 22nd of April also. But I'll take another 2-3 days. It is a very huge case. We'll deal with every point. It is not going to be over before Bihu. There are a lot of nuances in this case.
Okay, 25th and 26th. 25th?
25th, Lordship.
Okay, 25th and 26th will complete.
26th, Lordship, there is a match in Guwahati. Let it be 25th and 27th.
Yeah.
Lordship is also going to enjoy that.
Okay. Council for the petitioners, Mr. P.K. Rochuri, Learned Council, P.K. Rochuri, Mr. A.K. Taludar, H.R. Suvri, H.R. R.C. Paul, and other Learned Council for the petitions are present. Mr. D. Hoikia, Learned Advocate General, has made submissions for the respondents. Assisted by Mr. K. Kaur, and K. Kaur has made his submissions partly as the hearing, as his submissions are not completed, list the case on 25 cases, 25/3/2025, as sought for by him, Mr. R. Dubey. He'll be associated with advocation or separate? R. Dubey, Standing Counsel, Assam State Election Commission, is also in attendance. 25.
Yes, highly.
Our small
We'll keep
submission.
then, we'll keep the day,
25th,
day, entire day.
and very well.
My lord, kindly our submission may be recorded regarding anxiousness
Or
of
maybe
the
at 2 o'clock.
election, my lord, for going to be, maybe declared at any time, my lord, we are anxious.
We are hearing on the hearing stage. We are hearing the matter finally.
Lord, my lord,
Already something has been made. Mr. Taludar, the principle of res judicata also applies at different stages of the same proceeding. When the coordinate bench, my predecessor, who was hearing, he declined the prayers in respect of others while accepting 9. And that has been reversed by the division bench. I have to see the principles of law also.
Yes, ma'am.
At the same time.
Of course. My lord, only part is that our submission may be recorded, that we are anxious.
No, everything, why should at the hearing stage we should record? Make an application, we'll see. And that has to be vacated by the division bench.
Yes, ma'am.
Or
My lord, my name may be recorded, my.
okay, HR survey.
AHMR survey.
AHMR survey. Yes.
Lord,
Give all the names. I'll record all the names.
My lord, my item number 42, it is something different, my lord. I am not against the delimitation, my lord.
This can be addressed by Mr. Resolved by Mr. Kaur and Dubey.
Yes, your lordship. My lord,
Okay, we can.
very limited prayer is there, my lord.
What? House? In one case, Mr. Soikia, husband was in another panchayat, wife was in another panchayat.
No,
Yes, in your case, what?
my limited prayer is that, my lord. Basically,
Tell
this
me,
case
without
is-
going into it.
My lord, this case against repeated reservation for female candidates.
Oh, that is, we are not,
My
okay.
lord.
Oh, we separate it.
Yes.
My lord.
Reservation, we are not hearing it. That is a separate issue.
My prayer is very limited, my lord.
No, no,
I
that is a separate
We
issue.
will give response to
We,
that also. That
we
is
dealing
clear.
it from this.
Yes.
Dealing this one.
Item
Because
40.
reservation is another thing. That has to be
My lord.
as per data and all.
No, sir.
That will be, I think, census data,
Yes, yes.
then
Very interesting topic that.
that is a different topic and very difficult topic.
Difficult.
We are dealing it separately. It was inscheduled. The WBC number so and so is to be delinked from this batch of writ petitions. And list the case. Is to be listed on 27th.
My lord, 25, my lord. On 25, my lord.
No, you are not addressing reservation. We are hearing the other points. I'll hear you special treatment 27th separately. Right?
My lord, let it be on 26th or 28th because it should
Okay,
not.
okay.
So that we would like to file an affidavit also. The
Okay.
Lordship is fixed on the hearing day.
On 26.
When do you want?
26th
Wednesday,
Wednesday or
Okay.
Friday.
26.
My lord. Mass of
26.
My lord, item
More preference has been
43 also. my lord. Item 43 also, saying my lord.
Item
43,
43.
43.
Okay, to do reservation.
reservation. my
Okay, reservation delinked and 26.
lord.
Anything else? Any other matter? Huh? Just me. Show me because reading and reading I could not show me because reading and reading I could not understand.
My lord, if your lordship permits me, in the 18 argument submitted by senior counsel KP Pathak, the ratio has been laid down, giving their numerical number as X and Y.
Numerical example,
By X and Y. By
not X and Y. Tell me in, not X and Y. I have not
no
understood.
alphabetically, but numerically, all right.
Tell me by 100,000 like that.
Numerically, not
Then
alphabetically. All right.